Going to open the public hearing on Senate Bill 431, and I will call Senator Carson.
Good morning, Madam Chair, and good morning, members of the House Children and Family Law Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 431, relative to child support cases in equal or approximately schedules. The bill establishes methods for the adjustment of child support for equal, again, or approximately equal parenting residential responsibilities. Um, this this legislation, it comes from the Child Support Working Group. If you remember, last year we had quite a few bills dealing with this particular issue. And Ms. Honey Hastings, who is here today and is going to be testifying, offered at that point to put together a child support working group of professionals to address this issue. And the legislation that you have in front of you is the result of that working group's efforts. So at this point, I am going to conclude my testimony. The working group members are here, and they will be able to walk you through this bill much better than I can. Thank you very much, Madam Chair.
Are you taking any questions or?
No,
Okay.
no.
So then I'm gonna, thank you very much.
Thank you very much, Madam Chair.
I'm gonna go ahead and call up Honey Hastings first. And she said she needs 6 minutes to speak, and she does have written testimony.
Madam Chair, members of the committee, I'm from Temple. I spent about 34 years as a family law lawyer and 22 years which continue as a certified family mediator. You may remember, some of you were around in 2018 when we had the alimony working group, and this was a similar group, somewhat overlapping in membership. Oh, I forgot to mention, I think the first time I was privileged to testify before this committee was 1987, when you were considering codifying the property division law. And it passed and I think has worked. The Child Support Working Group, and my testimony has a description of the group and lists the names of people at the bottom. 3 of us are here today to testify, brought together our years of experience. I think I must have done over 1,000 cases over my years of experience. So, and I represented dads, I represented moms. In the early years, I represented a lot of dads in primary parenting cases because that was considered unusual in '82. And since I've been doing mediation, I have been a neutral between lots and lots of parents and try to get them to an agreement. And what came out of our looking at what the bills from last year is a need to focus on one problem that perhaps could have an easy fix without a big study, but it needed some study, and that was what to do in the equal and approximately equal cases. Our goal was to clarify the law because the law does spell out what to do, but it could be clearer. Please note that approximately what child support is going to be and all the other issues. And the 10% that don't have a settlement, not all the issues are about child support. Some of those people settled child support and are fighting about the pension or the vacation home or alimony, although not so much in recent years. When you hear about litigated cases, this is one person's experience, and I think you should weigh it accordingly. We thought the first thing to do was to figure out what was important, what was the criteria we wanted to apply in finding a method. And we It's shown on page 2 of my written testimony that we came up with this test that was first thing fair to the child. Child support is about children. It's not about payors and payees. And the current statute says the purpose of child support is to minimize economic consequences to children. So we felt that that was clearly the first priority. The next was a reasonable lifestyle for the child in each home. Right now, that's in the law as a test that says to meet the cost of child rearing in a similar or approximate equal style to the other parent. So those two tests those two factors are in the current law, and we thought they were good ones. We felt it was important that it be understandable even to self-represented parties. And we felt it should distinguish between those cases where guidelines child support is appropriate in light of fair to the child and reasonable lifestyle, and those that need an adjustment. And we felt it should continue the longstanding requirement of equal or approximately equal. So with those in mind, we started exploring what the options were. To be frank, we started early on looking at the bill that Representative DeSimone put forward, which would use net the difference in all equal time cases. I had used that test, I had used that process for at least 20 years, maybe longer. Other members of our group had also used it in appropriate cases. In other words, it was a settlement tool. It has a lot to be said for it. It's simple, it's straightforward, it's easy to understand. But when we got into it more, and Tony Matramalo, who's here on our team, will explain how we got to the fact that we concluded it wasn't fair to children when the parents' incomes was substantially different. So, yes, net the difference, but limiting where it comes from. I'd like to just go over the bill and touch on some high points. First, we collected all the components that deal with making adjustments to guidelines because of equal or approximately equal into one new section labeled 5A, 458C 5A. You'll see it start on page 1, section 4, line 4. So all the material that has to do with this concept is in one place. It's not the way the law is now, and this we thought would be easier to follow. We stuck with equal or approximately equal. And you might say, what's that mean? Well, I can tell you, it doesn't mean 51 to 60. It means equal or approximately equal. It's hard to give a number of overnights, which some would do, because that is not the whole test of equal or approximately equal. For instance, there might be a 40-60 overnight, but there might be every school day afternoon with a 40% parent. So, but because of work schedules, the overnights are not so closely split. So our view was the courts seem to have been able to recognize equal and approximately equal. It's been the law for some time, and we just stick with that. So we put in there a new test for varying because of equal schedule, which is best interests of the child and meeting the cost of child rearing in a similar or approximately equal style. You recall that's similar to one of the tests now. Our tests eliminate any reference to fixed cost because it seemed to be less useful, more problematic. Starting on line 14, section 3, there's an optional test if the court thinks it is useful in considering whether the lifestyle is similar. They don't have to use it. It's not required in every test. And then looking further down, line 24, this is the existing law that when ruling on these requests for deviation because of approximate equal schedule, they can look at whether the parties have allocated expenses. What we added in there is on line 27, and they have provided a specific procedure for implementing the apportionment. It is problematic when people say, we'll just split all expenses, or we'll just split all, extracurriculars, and they don't have a method spelled out. So by asking people to put in how they're going to do it. Maybe they're going to keep a joint account and each put money into it and use debit cards to take money out of it to pay for the extracurricular. Maybe one parent is going to handle expenses A, B, and C, and the other parent's going to handle expenses D, E, and F. Some plan for how it'll be doing, because we've seen that that can lead to our fights. We've given a definition of variable expenses just because there seemed to be some confusion. People didn't know what variable expenses were or the difference between variable and fixed. So we're trying to clarify the law by defining them. Looking at page 2, line 3, here's something we added. If the court is making an adjustment because of equal schedule, then the court needs to allocate the cost of daycare, after school, vacation, etc., summer care, unless the parties have done so. Here's the problem. Currently, if you have guidelines, the person receiving the guidelines is supposed to pay such expenses. But if it's not guidelines, that presumption may be inappropriate. And we're saying if you're going to lessen the support, then just say who's going to pay which of these expenses, which, as I'm sure you all know, have only increased in New Hampshire. Line 6 on page 2 starts out and explains the difference. So what you use the worksheet, and I think you'll be getting worksheets in a few minutes from Tony. There's a point on the worksheet where it says, when we look at the parents' proportional incomes, this is the portion of the child support that is attributable to one parent and then to the other, and it gives a percentage. So you can look at the worksheet and you can see right off whether it's more, 60% or more, or it's less. So what we're saying is, in cases where the differences between the incomes is such that one parent's income is less than 60% of the total, that was based on our experiment of doing multiple scenarios and playing them out, then you take the support that the form gives you already. The form gives us for the high-income parent, and the low-income parent, subtract the lower from the higher, and that number is the difference number, and that's what would be paid by the high-income person. This seems to work and come out with fair results, which Tony will say more about in this income situation. So I think that's a review of the bill. I'm open to questions, Madam Chair, should there be any from the committee.
Representative Yokella.
Thank you. Thank you for taking the question. How did you decide what criteria did you decide for this working group membership? And did you request or did you reach out to the public? Because I don't see any families or judges on this.
Well, judges would not participate in such things. They have to stay apart from any more than they'd be on a committee you would set up. I spoke with the people who had been with the alimony group and looked out for more people with a lot of experience helping people settle these cases. And that's how I invited Tony to come on it, because he is a professional mediator who spends every day helping people settle their divorce and parenting cases. And while I'm kind of semi-retired and maybe have done a couple dozen cases in the last couple of years, I don't know, I think he's done hundreds. So he has seen people, parents, as a neutral, he has seen parents struggle with this question, helps them with their financial forms, and what is the need? How do we get the child taken care of in both homes with reasonable lifestyle? And he seems to have a pretty good success rate. He'll tell you more. You know, I see this as challenging, but maybe it's my lesser skills in mediation. He seems to be generally successful in getting people to come up with a solution. So we didn't put a call out, if that's what you're asking. We looked for people that had lots of experience in doing this kind of work, because if I've had 1,000 cases experience and someone else in the group has had 1,500 or more and someone else has done 500, the total number of cases that we're bringing to it is really different. We knew that when we got here to having a hearing, when you had a hearing, that you would be reaching out in a different way and would have parents, but each parent just gives his experience or her experience of one case. And without having the case file and reading it, maybe even listening to the testimony if it was recorded, you can't really know what happened there.
Thank you. So I guess to summarize the question, it was the criteria was that you just looked in for the people that you knew that had experience in this, and you chose the people to be on this working group. Is that correct?
People volunteered. As you see, looking at the bottom of my testimony, it's on page 4, we have Mary Krueger, who is here today, and Erin Jacina, and they are with New Hampshire Legal Assistance representing many impoverished people in divorce. Marilyn Mahoney is not here today because she had a conflict, but she has an experience similar to mine. I think we both testified in '87 on that property bill, has been interested and testified on a lot of policy questions. As I mentioned, I invited Tony because he's doing so much mediation, and William Woodbury is more of a generalist, but does a lot of family law, and he's active in the New Hampshire Association for Justice. So we tried to get a diverse group, didn't say no to anybody, but really we just needed people who were willing to spend a lot of time. I mean, I think the amount of hours we spent in the last week would be, I'm sure I spent the equivalent of a day and a half, 30 hours or more myself, and other people spent similar time. People who had the time, a couple retired lawyers, a couple of lawyers currently in practice, so we wouldn't have stale information, a full-time mediator,
I follow up.
It's actually a new line of questioning.
Oh, new line of questioning.
But thank you. When you say that that the parents would have equal capacity to raise their child, were there any factors other than monetary that you brought into that equation?
Thank you for your question. This was not a bill about how to assign parenting time. Again, keep in mind, approximately 90% of parents get this sorted out. Less than 10. And I would say as to parenting, probably the percentage that settle is even higher. I was talking about divorces overall. But as to parenting, most parents who are certainly the specialists on their children make those decisions. They may need some help with a case manager or a mediator in saying, you haven't done anything about vacations. Won't there be vacations? What kind of schedule will you have that? Or will the schedule be different in the summer than it is in the school year? But they know the basic schedule. And hopefully they've actually been living it for a month or two before they write it down or carve it into the granite through age 18.
One more follow-up. Other people have questions.
Yeah, sure. Thank you. So one of the things that is currently in child support is that they're trying to figure out how much of the combined income would go towards the raising of the child, or how much money of that would go towards the raising of the child. And in shared and equal parenting time, or approximately equal parenting time, some of that money would be spent while the person is actually parenting. And so I guess my question is, when you were considering the factors as far as what is appropriate for each person to be required to pay the other person. Did the amount that the money that they spent actually raising the child come into play in some way?
I know the other bill that you testified about, and I was able to listen to your testimony, was dealing with changing the percentages, the tables. But let me say this, that since we've had the guidelines, which is 1988, the parent paying guidelines has always spent more money on kids than the guidelines. This idea that that number on the child support worksheet is you can't require anyone to spend $1 more than what's on there. It's just not been the experience in New Hampshire. People paid the guidelines amount to the other parent in kind of traditional schedules. We're not talking about the equal time schedules so much, but and they've always, when they had the child, say in a traditional schedule of alternate weekends and Wednesday overnight, then they still fed the kids on the alternate weekends with their additional money over what they had given to the other parent, and on Wednesday night, and they took the kids out for pizza, or they went and did some sport event with the children. This has always been so. It's the idea that they should not spend anything more on the kids is, I think, is not child-focused. And when you come to equal time schedules, you have the additional consideration of it costs more to raise children in 2 homes than in 1. And that's why the 2018 UNH report, I have some criticism, but on this point they're right. It costs more if the kids have to be outfitted with everything in both houses. They called for using a multiplier. That is, you calculate the child support in the usual fashion, and you multiply that child support number, that guidelines number, by 1.5 to account for the fact that it takes more to support kids in 2 households. And then only then apportion it between the children. And that was in 1647 as introduced, but your amendment, Representative Yukela, removed the 1.5 multiplier, so that's a further problem. It takes more, and it takes more than guidelines to raise a child, especially if 2 households have to be fully outfitted.
Representative DeSimone.
Thank you, Madam Chair, and thank you for taking my question. Taking into consideration your last statement of it does cost more to provide 2 homes for children. I'm looking at on page 1, line 28, Roman numeral 6, and page 2, line 3. It says here that the variable expenses include but are not limited to education, school supplies, daycare, after school programs, vacation, and summer care. So, taking into consideration the additional costs of running 2 homes for these children, why would we make it a law that specifically states that if Johnny wants to go to Hawaii for vacation, one or the other parent has to pay for that? I don't see where after school programs, vacation, and summer camp should be included in the law. Can you explain the thought process there, please? Thank you.
Thank you for your question, Representative DeSimone. So it appears that your question primarily is talking about what is on page 3. That is, when the child support is adjusted, that these kind of child care things need to be considered. Am I right that your question primarily applies to that?
No, it applies primarily to things like vacations, summer camp, driver's education, if one person disagrees that vacation is paramount to the child's well-being or driver's education, why would we put that in law? That should be something that should be agreed upon between the parents and maybe a mediator. Would you agree?
Well, mediators don't make decisions for parents. We help them come to the decision.
I get that.
I'm happy to clarify that. So the part that's on line 28 of the first page, which is essentially a definition of variable expenses, really relates to the prior section 5. So in ruling on requests for adjustment because of the equal schedule, the court may, doesn't have to, may consider whether the parties have agreed to specific apportionment of variable expenses and a procedure for implementing that. So this is if someone's requesting a variation from the guidelines, the court can consider, and this I think would come up primarily in cases where the parties in fact have agreed to a deviation. You can't just have, in my experience as a mediator, I can't just say the parties don't want to do guidelines. I have to put why. I have to justify it under the current law, like shared schedule and an agreement to split these costs. That's the kind of thing I write in the uniform support order. I don't know that the court would approve a non-guidelines order if I didn't write in the reasons. So the fact that apportionment of variable expenses is something that can be used to justify a variation in the guidelines, but that came to be, as you've seen and I've seen over the testimony recently of the various child support bills, is and because of Silva, what is a variable expense? So we just simply said, here's what we're talking about. So if the parties are saying, please approve this, we've already sorted out all the expenses, then the court would be able to say, okay, I've seen you've done that. And as to the part that's on page 3, Roman numeral 7, here's the concern, as I said. Right now, there's a presumption of how those daycare costs are met. The person getting the guideline support gets it. But it's not clear what happens if there's not guideline support. And, you know, the allocation may be equal sharing of it, and it's if they agree to it. I mean, if in fact there's no after-school care because the kids are teens, or the little ones are with one of the grandmoms who doesn't ask for any money, then there's no cost. But if there is a cost, and for most families there is a cost which is only increasing each week, it seems, then we're saying the court can't adjust the child support without deciding that one way or another. It may be that one parent still has enough to pay the whole cost. It may be you want to take those percentages on the worksheet and divide up the child care, 60-40 or whatever the percentages were. So this does not require anyone to approve of vacations or any of those other things. It's just if they do agree on that, then that could be a factor in approving. Yeah, you can definitely say no to no vacations. I mean, no summer camp. I want the kids to stay home. That's a parental decision.
Representative Belanger.
Thank you, Madam Chair. Thank you for being here and providing your testimony today. Barring any unforeseen domestic violence or any issues, right? Assuming that a family is, I want to say normal. I'm putting that in air quotes, right? Do you agree that if there are two parents in a situation, taking out any negative scenario, that they should be sharing custody? Parenting time. Thank you.
I'm sorry, I was just going to.
I got it.
Thank you. If we could only get the Supreme Court to use the right words. I don't dare correct them. I wrote the Parental Rights and Responsibilities Act that got rid of custody. So I kind of take it personally. Parents, very few parents fail to share the care of their children. Sharing doesn't mean 50-50. Most parents work out the plan for and the timing of the sharing. So I think unless there's some very good reason, someone is incarcerated, there's been violence, particularly violence against the children, someone is stationed in the Far East, absent some reason like that, well, it's written in the parental rights and responsibilities law. Most kids do better when they have frequent and regular contact with both parents. I believe that. But most parents do not choose a 50-50 schedule. An increasing number do, compared to 1982 when I started practicing, and the male lawyers in Nashville wouldn't take a guy who wanted sharing or more custody, which we had then, because they couldn't understand why he'd want it. But things have changed. Society has changed, and I think it's for the benefit of children. Some people work in Boston and have a long commute. The other parent, hopefully, has stayed with a maybe parents' hours job locally or a job from home. And so to say that the time has to be equal, I don't know how you do it. One parent is simply not as available. There are the schedules of uniformed services, which have a rotating schedule. It's really challenging to come up with a time, but it's typically following something that has been worked out in terms of the work schedules and availability of each parent. There are also some parents who don't want parenting as much as public policy would say would be good for children, and I think that's regrettable. But that is true. I think it's usually, though, practicalities, including work schedules, that mean a 50-50 schedule just simply won't work for all parents. They decide. If they decide alternate weekends, Wednesday night, but more time in the summer is what works for them, who are we to say, no, you must have the children 50% of the time?
Representative Altschiller. I'm sorry, follow up. Sorry.
Thank you, Madam Chair. Thank you for your question. I think, or thank you for your answer. Sorry, I'm not here today either.
I'll thank you for your question, which has got me thinking.
Dealing with stuff at work, it's not great. So
Work.
and I'm going to preface this. So in my instance, I own a business, right? And you know, I may pay for everything, but what you alluded to was that it is more costly to provide two homes. So my expectation is, while I see my kids on a regular basis, now of course my wife and I aren't separated, but in the instance that we were, my expectation was to be paying for both of these houses. I'm still seeing both my kids, but I mean, we've got to figure out a way to drop this down. But in the instance that it cost, to your point where you said it cost more to have two homes, to pay for two homes, is it your expectation that if a parent is sharing equal parenting time, I said that right that time,
Good.
that they're not paying as much for child support?
I think what we need is what's fair to kids. And if what's fair to kids, again, I don't see the guidelines number as a magic number, and it would be against public policy for parents to spend any more on their children than what the guidelines number produces, because since '88, guidelines paying parents have still fed their children during their time, which used to be called visitation, but of course we don't use that word either. So I don't think it's harmful if you look at, and I know the courts would, look at the budgets of both households, look at the income. When the income is so much higher, after paying guideline support, the high income parent in most scenarios is still going to have more available income after child support than the parent who receives child support. you need to look at examples. And again, Tony will say more about that and has an exhibit that talks about that more. So I hope you will ask some of those questions again with his material in hand.
Okay, all set? Okay, Representative Altshuler?
Thank you, Madam Chair, and thank you very much for being here today. I want to dial back, and just for a clarification, in current statute, in 458C, Part A, which reflects this bill as amended by the Senate, lines 28 and 29, I want to clarify that the variable expenses, the first 7 are include but aren't limited to education, school supplies, daycare, after-school programs, and then the words here are vacation and summer care, then followed by extracurricular activities. So vacation and summer care is actually referencing when schools are not in session.
That's right, and thank you for calling that to my attention. I didn't catch that when I was trying to answer Representative DeSimone's question, but it's talking about February vacation, April vacation. And again, those are some of the biggest out-of-pocket expenses parents have. You know that if you have kids or grandkids. That's just huge, especially the little kids.
Right. So may I finish my question?
Follow up.
So my question in pointing that out was, if one of the parents has the available disposable income to take their children on a vacation up to Lake Winnipesaukee during the summer, and the other parent does not have the disposable income to take their children on a vacation up to Lake Winnipesaukee for the summer, this bill does not require that the parent with that disposable income provide that to the parent that doesn't, so that they each get an equal vacation, correct?
Correct.
Okay, thank you very much.
Do you have a question? Anybody else? All right, seeing none. Oh, okay, Representative Yokela, we're really
that-
running short on time, so.
Now
keep
that
wrapping
we
this
are,
up.
now that everyone else has a chance, I had a question about you mentioned this that the cost for having 2 households is increased, and how is that dealt with in this proposed legislation as far as the increased costs being necessary for a two income household, especially how does it address the increased costs with people that have, let's say, 61% of a difference of income, 61, 49%,
Well, thank you. That's for your question.
39, sorry.
What we found in the examples, please ask them when you have the scenarios, is at that income level, at 60% or more, after that parent paid the guidelines, which would enable the other parent to maintain the children, the guidelines payer still had more money than the lower income parent. Still had more, and yes, again, it would require paying dollars that are not in the guidelines number. As I said, that I think it's a mistaken idea that that's the limit on what parents could spend. So yes, but there's enough, and that higher income person, by our calculations, had enough to support him or herself and the children because the income was so much higher. Yes, more than the guidelines could be spent.
Follow up?
Thank you. Would you agree that the guidelines are not a maximum amount, but actually a minimum amount that is required to be spent, because that is what is required to be paid to the other person that is available for that money to be spent on the children?
I certainly agree that it's not the maximum. I wouldn't say it's the minimum because, in fact, this bill proposes cases where the guidelines would not be paid. So, in cases that under our bill guidelines should be used, then I guess it could be, except there are other factors in 458C5 for varying from the guidelines other than parenting time. And it has to do with extraordinary health expenses, the cost of college of kids. I don't remember the whole list, but there's 4 or 5 other factors that could be, a very high income, a very low income. Those also are reasons for varying. So the guidelines are kind of what they say, guidelines.
One more follow-up.
Thank you. In referencing to this variable expenses and deviations, could someone, where they haven't agreed, where one parent is going to Hawaii and request the court to have a deviation because
Can
they
you hold on one second? Because
Yeah.
they addressed that. This is not regarding a vacation going somewhere. It's
Yes.
regarding school vacations.
that's
That
so
they're at home.
so would you agree that it says other child related expenses and not limited to?
Oh, I would agree. yes.
Okay, thank you. So
But that's not what you were asking.
so would you agree that they don't have to agree about the variable expense before they go to court to request a deviation for that variable expense cost?
They don't have to ever agree
Thank
on
you.
variable expenses, but they can't use it as a factor to justify an exception to the guidelines unless they agree. We haven't changed the law on this as far as the court deciding about variable expenses, except daycare, which we've indicated the court has to do that if it deviates. If it doesn't deviate, it doesn't have to allocate the daycare expenses.
Thank you very much for your testimony. For the rest of the people who I have cards for, I just ask that you do not repeat what has already been said, okay? Because we delved into a lot there. So up next will be Anthony Matrimalo from the Child Support. Did I butcher that? I'm so sorry. He's asked for 5 minutes. Oh, and do you have, is that written testimony? Okay.
Good morning. I want to thank everyone for giving me the opportunity to speak today. My name is Anthony Matrimalo. I am a certified family mediator. My experience is I work with families every single day in my office dealing with this issue. It is rare that a day goes by that I'm not talking about child support or parenting with multiple families in my office each day. I have served as the president of the New Hampshire Conflict Resolution Association. I was appointed by the governor to serve on the Family Mediator Certification Board. I have a lot of experience working with people on families. That's the overwhelming majority of my practice is family law situations. And I was asked to join this group. Honey Hastings approached me. She knew me from my experience as a mediator and asked me if I would be willing to spend some time working on this issue because there had been bills that had been introduced that people felt had not solved the problem yet. So I agreed to be a member of this group. I will tell you that I am a neutral. That's the way I earn my living. So I work equally for the people who are paying child support and for the people who are receiving child support. If at any time I show a bias toward one of those parents or the other, I have failed to do my job. So I have to be able to look at these issues, help people reach agreement, but not take a position that favors one client or the other. I will tell you, I have worked with hundreds of families resolving this issue, and I have never encountered a family that was not willing to stay at the table and work at this that has not been able to resolve child support. What that means is, I think that the legislature in New Hampshire has done an excellent job of providing people like me, mediators who work with families trying to resolve the issue, as well as judges in those minority of cases that are forced to make decisions because parents cannot agree. The law that you have in place now allows me to do my job. It gives me the tools I need to have these people make decisions and settle these cases themselves. And what I will say I would say the majority of my cases involve approximately equal parenting schedules. Because in the law it says that children do best when each parent has a meaningful, continuing contact. The child has that with each parent. It's encouraged that each parent spend as much time as possible. So parents agree to that in the majority of cases that I work on. But at the same time, what they agree to in terms of child support varies depending on the specific circumstances in each case. So let's bring common sense into this. If we have one parent who earns $20,000 a month and another parent who earns $2,000 a month, and I've passed out a child support guidelines worksheet that I helped a family complete a week ago. In that case, one parent earned $160,000 a year, the other parent earned $30,000 a year. They had 5 children. The guideline said, I believe it's $3,302. In that case, the higher earner was the father. They had an equal parenting schedule. And the father said, of course I'm going to pay the guideline amount of child support. Just look at my income and reduce my income by that $3,300 and add it to the mom's income. And you can see I still have a huge disparity in income. I can support the children fine on my end. So what the law is we have to keep the focus on the welfare of the children, because what's good for the children is good for the parents. I'm a parent of 5 children. I don't know how many of you have children, but I learned a long time ago that a parent can only be as happy as their unhappiest child. So that is what it is, and that's what I try to keep my clients focus on. I don't care what you agree to, it has to make sense to you. So in equal parenting cases, if you have 2 parents who earn similar incomes and have the children a similar amount of time, in a case like that, most parents agree to no child support. We have equal income and we have equal expenses. We have the kids an equal amount of time. It's common sense. So they put in these agreements that are presented to the court, no child support in a case like that. I have never had a judge fail to sign that order, okay, or ever question it. If you have 2 people with this example I just gave you, they agree to guideline support. It's common sense. This is not something that's controversial. Where you get to the area, and then there's everything in between. I have many clients who don't agree to guidelines, but they agree to something just less than the guidelines. So Representative Ukella, you asked a lot of good questions, and I think one of them was, what do you do in a case when it's 61%, 39%, right? And the answer is that you use judgment and common sense. Is the guidelines right? Well, maybe what we're doing is putting bumpers in the bowling alley with this Senate Bill 431. The high end is guidelines amount. The low end is 0. But in cases we have net the difference, right? We put that lower that lower bumper there that has never existed before. And actually, this net the difference idea has never been articulated in law before. So that is what we're doing. We're providing, you guys have given us the tools. We have the tools. If you had a carpenter come to your house and he butchered the job, are you going to blame the hammer? No, you're going to blame the person who's using the hammer. We have the tools. We don't want to throw out, right now, there was an article in the Concord Monitor several months ago that talked about the data for New Hampshire children. We rank second in the country on the metrics associated with child well-being. That's because of what this body has done to put the focus on children. We only have I say only, it's too much. 7% of our children in this state live below the poverty line. The national average is 17%. That's 143% more than what we have accomplished in this state. So this is not the problems that people are talking about here, and the people who testify against this bill are well-meaning people. They're not bad people. They may have had a bad experience, and they look at these laws through the prism of that experience. I'm telling you, I'm looking at this from a neutral standpoint. I can't tell you how many hours I spent working with this group to try to come up with this solution. I think it solves the problem without overstepping and throwing out the baby with the bathwater and harming children in the long run. We don't want to be in a position 5 or 10 years from now where the Concord Monitor is writing an article about how we've fallen from second to 27th.
Okay,
in
I'm going
child
to ask
well-being.
you to,
That's it.
I got a handful
That's
of
it.
other people
Go
that
ahead.
want to testify. Are there any questions? Representative Yokala.
Thank you. Thank you for taking the question. It seems like there is a goal of equaling or reducing the difference between incomes for more so that they have a more equal standard of living at each household, instead of that each parent has the ability to pay for the their share of the response. What is it called? Their parental support obligation. Can you speak a little bit towards that question?
Sure, certainly. So I think there's again, what I see in my office is there is a general rejection of the idea that any amount of child support is going to flip incomes, so that the person who earns more pays so much child support that now they're earning less after child support is paid. That's, again, common sense. That's something that every client understands. I've never had anybody propose anything like that, right? And we're not talking about, of course, the goal is so that children can have a similar experience in both households, because it is in the current law, which I think is good law, there is a recognition that children do best if they don't view one parent as the parent who is able to support them and the other parent as the parent who is incapable of providing that support in their household. So they go to one house and they live in opulence and they can afford to do all these things. They go to the other house, they don't have their own bed. They're sleeping on the couch. There aren't enough bedrooms. If you have teenage boys and girls, you need a 3-bedroom place. So there are realities. The financial affidavit, again, talking about common sense, the financial affidavit on page 1 lists the income. On page 3, every client, every parent that goes in front of that files a petition with the court has to show what their reasonable expenses are. When they're filing a joint petition, each party has to agree that what's on the other party's financial affidavit is reasonable. So if one person is earning $2,500 a month working full-time and on page 3, reasonable expenses are $3,500 a month, that is not sustainable, a $1,000 a month deficit. So if the other party has the surplus, has the income to supplement the first party's income, the state acknowledges that that person, since they have the children and they are the other parent, is more appropriate to be providing that support than the state would be. So in effect, it isn't to equalize the incomes. It's for one parent, if necessary, to provide enough income to the other parent so that they can provide, again, a similar lifestyle, not the same vacation to Hawaii, but a similar experience for the kids in each home. Does that answer your question?
Do you have a follow-up?
I rather move on to something
Okay.
else.
Representative Belanger.
Thank you, Madam Chair. And thank you, Tony,
Yeah, totally.
for being here today. I appreciate your testimony. I am by no means an expert in child support. I'm a child of child support, and I don't necessarily agree with it. However, my question is I don't quite understand. So if a parent on scenario 2, parent A is grossing, we're talking about this is your salary. Your salary is $65,000, correct? We're not talking about after taxes.
We're talking about in scenario 2, one parent earns $65,000, the other parent earns $60,000
Correct. And again, we're talking about gross
per
correct?
year. Yep,
Right,
correct.
before taxes.
Yep.
May I continue, Madam Chair?
Please do. We're
Thank you.
running out of time.
So, assuming that this parent is obligated to pay $10,000.92 based on your $841 per month calculation, is that correct?
No, it's not correct, because in that scenario, the person that would be paying child support only earns 52% of the combined income. So in that case, net the difference would be the presumed amount, or would be the amount that would be allowed. So where you look at the highlights, I'm sorry I didn't explain this chart. So if you look at the scenarios here, there are 5 scenarios. In the first 2 scenarios, the income of the higher earning parent is less than 60% of the total income. That's why in our bill in 431, it would say that net the difference is an appropriate option. So rather than the $841, we're saying it would be appropriate for that higher earning parent to pay only $17 a month. And then if you look at this, if you go over to the right of that $17, it shows what the parent's income would be after paying support and after receiving support. So in that scenario, the person paying child support, instead of $5,416, they have $5,400. The other parent, instead of $5,000, has $5,017. The difference in incomes are shown in that far right column. So if you look at the last 3 scenarios, those are scenarios where the higher earning parent actually earns more than 60% of the combined gross monthly income, which is more than 1.5 times the lower earning parent. So in those cases, we're saying the guideline amount would not be inappropriate. It still would be the presumed amount. However, the parties can agree to deviate, which they do every day in my office, or a judge can look at the factors and say, you know what, guidelines maybe isn't appropriate in this case because of these factors, and order something less than the guidelines. So I appreciate your question because, yes, you're right. If we were to use the guidelines, what we concluded doing our analysis is if the guidelines were ordered in that case, that probably would not be fair. So I agree with you 100%.
Thank you for that. And thank you, Madam Chair. I'm all set. Thank you.
Do you have a question? Representative Yokella.
So in scenario 2, you agree that right now, under the current guidelines, it is unfair.
No, because under the current guidelines, there's a guideline amount, and then there are many, many reasons why the judge can factor in when deciding that the guidelines would not be fair. So the guidelines would not be ordered in a case in this case. So this idea, and I've heard this testimony before, that if one parent earns $1 more than the other parent, they're going to be ordered to pay the guidelines. That is untrue. That has never happened to my knowledge, and it has never happened in my office in hundreds of cases. I will tell you that. So I feel like that, I'm happy to answer your question.
One more. I still have 3 more speakers.
I understand, but this is the public hearing, and we need to be
I
able to
understand that,
ask the
but there are
questions.
3 other people that may have
mean,
answers for you also.
That's possible. But do you agree that in the Supreme Court's ruling in Silva v. Silva says that a deviation is not allowed for the fact that it is equal, that parents have equal parenting time, and so that is not, even though currently it's not in the law, it says that it's not the sole reason, that the court has ruled that to be not a reason.
Absolutely not. That is a misunderstanding of the Silva ruling. The Supreme Court, the lower court in that case found that there was justification for a deviation from the guidelines based on the fact that the obligor, the person paying child support, had shown that there was a reduction in fixed costs to the obligee or the person receiving child support's fixed costs. The judge in the lower court went on to articulate what those fixed cost reductions were, and every one of the fixed costs that they articulated in the law, in the ruling, was not a fixed cost, but rather a variable cost. So what the higher court did, what the Supreme Court said was, when the lower court looked at this issue, it would have been possible, if the reduction in fixed costs were actually fixed costs that were reduced, that it would have been justified a deviation. It could have justified a deviation from the guidelines, but the lower court didn't say that. The lower court said it reduced fixed expenses and then used as examples of those fixed expenses several variable expenses. In fact, what they listed were in the definition of variable expenses in the law. So the lower court clearly made a mistake. The higher court had nothing else to do but to rule that the lower court had made and throw it back to the lower court and say, if you want to do a deviation based on a change in fixed expenses, then show us which fixed expenses were actually reduced. So that's what it was about. It wasn't saying that you cannot do a deviation from the guidelines. That's a misunderstanding of that ruling.
Are you all set? Thank you very much.
You're very welcome. Thank you for
Up
the
next
opportunity.
is Lisa, Kutowski, is that correct? And attorney Susan Brisham, who's asked for 5 minutes. So who's going to be speaking?
I will be.
Okay, thank you.
Thank you.
And you are,
Good morning. My name is
okay, go
Lisa.
ahead.
For the record, my name is Lisa Dekatowski, and I am the Bureau Chief with the Bureau of Child Support Services on behalf of the Department of Health and Human Services.
And I'm Susan Brisson. I'm the Chief Staff Attorney for Child Support.
Thank you for the opportunity to speak, and good morning to everyone. The Department of Health and Human Services, through the Bureau of Child Support program, administers the child support program for the on behalf of the Title 4D Social Security Act. And we're really here today to just provide the committee with some information to ensure that you are aware that the Department of Health and Human Services, as required by statute, is currently going through a guidelines review this year. And we do anticipate that the review will yield some very helpful and recommendations for the legislature to consider in regards to the child support guidelines. Certainly, the review considers the economic data of the cost of raising children and includes an analysis of case data on the application of and the deviations from the current child support guidelines, and will provide recommendations and findings and an analysis of current data available to us for the purposes of the quadrennial review. The report is anticipated to be completed by the end of this calendar year, as of December 31st of 2022. And again, we just want the committee to be aware that we do anticipate that this review report of our current child support guidelines and the data that is available to us will hopefully yield to some helpful recommendations.
Are there any questions? Representative Yokella.
Hi, thank you. Have you, are you aware of the 2018 guideline review and the recommendations that it proposed? I guess that would be my first question.
Yes.
Are you a part? I guess. Are you a part of the, or you know of the current workings of the current review, and if there is like conflicts or differences that you have identified thus far between what your current review is and the 2018 study?
Thank you for that question. So the review is in its infancy stages of data collection. We have contracted with a vendor who commenced the analysis that they will complete this year as of January 1st of this year. So we are in the preliminary stages of data collection and review and analysis with our vendor that's been contracted. So what their recommendations or findings may be at this point in comparison to the 2018 guidelines review report is yet to be seen.
Follow up.
Absolutely. Thank you. So you have no reason to believe that they wouldn't come up with the exact same recommendations because we haven't followed those 2018 guideline recommendations.
I don't know what their recommendations
Exactly.
would be,
Thank you.
Representative Yokella, at this point. Thank you.
Representative Altschiller.
Thank you, Madam Chair. I just wanted to know, when you filled out your pink card, did you fill it out in neutral, that you're just here to answer questions,
Just to
or
provide information.
just to provide information? Thank you. That's all I want to know. Thank you.
Thank you.
Are there any further questions? Representative Yokella.
Thank you. For this study, how much are we contracted to pay for this study with the new people?
The total contracted amount with the new vendor, I believe, is, bear with me one second, approximately 136,000.
Thank you.
All set? Any further questions? Seeing none, thank you very much.
Thank you.
Up next is Mary Krueger from New Hampshire Legal Assistance. She has written testimony. She supports the bill, and she's asked for 5 minutes.
Thank you, Madam Chair.
Thank you.
My name's Mary Krueger. I'm a staff attorney with New Hampshire Legal Assistance. We're a statewide nonprofit law firm. We represent low-income and older Granite Staters in a wide variety of civil legal issues, mainly surrounding poverty law. We operate a domestic violence advocacy project. I'm an attorney on that project. We represent victims and survivors of domestic violence, sexual assault, and stalking in protection order cases and family law cases. We prioritize cases that are high lethality cases, and those are cases where the violence is severe and continuing. And so we see some of the worst cases that you can imagine going through our family courts in New Hampshire. I've been doing this since 2006. I was part of the alimony working group, and we were really looking out for the interests of domestic violence survivors. If there's going to be any law change to child support, that can have a huge impact. It can also have a huge impact on people living in poverty, children in poverty. And we're very concerned when we see changes being made to policy around child support in our state, because we want to ensure that more children don't go into poverty. New Hampshire does quite well, and is second in the nation in terms of the lowest poverty rate. And we'd like to see it stay that way. This bill here really just focuses in on one aspect of the current law, that would address equal and approximately equal parenting schedules. It still presumes that the guideline amount is the amount of child support. And we think that that is an important policy to maintain, because domestic violence abusers use coercive control in the form of violence and financial control, in addition to emotional and psychological control. The financial component can be used as a way to keep a victim in the relationship. Oftentimes, abusers are the higher earners. Oftentimes, abused victims aren't allowed to work, or only allowed to work very low wage jobs. If we have a situation where an abuser is incentivized to decide to fight over parenting time, an otherwise uninvolved abusive parent may decide to do that if they see that there's an incentive to lower their child support obligation. With this change, it just provides more precise parameters, keeping the best interests of the children in mind, so that the courts, we litigate a number of cases. So I'd like to be able to mediate. Probably 50% of my cases do settle. Often when I have a good attorney on the other side, we can be the reasonable people to help move things along. But we litigate probably 50% of our family law cases. And so when we look at this law, I'm looking at it as how a judge is going to apply it. And the judge is going to keep front and center the best interests of the children, and to look at the lower earning parent to make sure that that parent can continue to meet the cost of child rearing in a similar or approximately equal style as to that of the other parent. And that those are the policies that would be in place that a judge would have to apply in order to decide if they're going to go to the next step of adjusting a child support when the parties don't agree. And we believe that that's a strong and important policy to preserve, especially for children who have been suffering in domestic violence homes. This also is protective of low-income people, because we have those bumpers in the bowling alley, as Tony mentioned, where if the court does decide to adjust it, it's in a fair way where people are earning similar incomes. And we think we often have parents who are both low income, and that's a fair way to allocate if there is an equal or approximately equal parenting schedule. And we do have cases that have those schedules. And we have two low-income parents. That net the difference could be a really good tool for a court to use in order to have a fair amount of support, so that parents can share the income across the household. So thank you very much.
Are there any questions? Representative Yochello.
Thank you, and thank you for taking the question. There were more recommendations than just addressing the equal and shared parenting time question inside of the 2018 study. Is there a reason that maybe the working group did not broach any of the other suggestions that were made in that study?
Yes, we were not looking at broad policy change for the child support law. We were looking at this very narrow special circumstance that's currently in the law regarding equal or approximately equal parenting time. Mainly that is because I've been in and out of this legislature for a number of years, along with Honey Hastings, sitting on some committees. This is an issue that keeps coming up about the equal or approximately equal parenting time and how to better guide courts in making decisions around that, given that more families are, doing equal and approximately equal parenting time. So it's been an issue in front of this committee many times. And that's something that we really felt that we could really devote the time and energy and brain power to figuring out. So that was exactly what we had committed to doing to Senator Corson last year.
Do you have a follow-up? Okay, are there any further questions? Seeing none, thank you very much.
Thank you.
Up next is Michael Dinar to speak in opposition to the bill. He's asked for 10 minutes. I'm going to ask you to bring it down to 5.
Yes, thank you. And my name is Michael. The last name is pronounced Dine-In.
Sorry.
Like dine-in or takeout is what the joke scientists came up with after years of research. I'm a father of 2 lovely young ladies. I'm from Rockingham County. I'm just a father who's been living the current guidelines since 2018. I've spoken on this matter a few times and have actually had reached out to the working group several times as well, and have spoken with Tony Matramolo and reached out to Honey Hastings, Aaron Jezian as well. I'm here today just to talk about SB 431 and the devastating nature of our current guidelines, which I think SB 431 would turn into legislature. So since Silva v. Silva, I think we're all aware of it. It hasn't been mentioned very much, but this is the reality. Every judge is, by precedent, case law, follows Silva v. Silva. There are rarely exceptions. The mentions of mediation, which is great and would be wonderful if most parents could qualify for mediation and work through that process, but most cannot because of, there were words like agreement, mediation. Most of them end up in court. Most of them end up having child support laws and guidelines established by individual family courts and judges. And since 2018, and this is reality, it's my reality, and for most every other parent, they actually established, because of Silva v. Silva, that the 2 criteria that were mentioned, one is reduction of fixed costs and also equal or approximately equal parenting time, are not justifications by themselves for a deviation from guidelines. So what that means is, whether a higher earning parent and lower earning parent have 50-50 parenting time, I have my children over 55% of the time, it does not matter. The lower earner receives all the funds available. I think everyone would agree in this group, everyone that spoke, that we know parenting is best for 50% of the time, that children do best with both of their parents. Because of that, that is the truth, and in my case, very much. But what happens is all the funds go just to one household, the lower earner. And it was stated previously, and I'll say it again, that means $1 less than the higher earner. So what I've actually, if I could pass out some of the
Yeah.
reference material, thank you. And it's in this, you get a chance to look at it and talk it out to everybody.
Well, there's not enough copies for
I think I have
everyone,
8
so-
copies. And I
Yeah, there's
apologize.
more than
I had one that got chewed by a printer.
fight over it, guys.
And I'll try and hit the high points and do this quickly. So what that means is, and I've provided some of the calculations, and this has been since 2018, of course. So if the lower earner makes $1 or just $1 less, all of those funds go to the lower earner. This is reality. This is not something that's conjecture or subjective, as a lot of the words you heard. And I want to talk about 431 in a second. But this is because of Silva v. Silva. What actually would happen with 431, it was take that and make it law. So it wouldn't actually even be precedent anymore, it would make it law. And the very important parts of this that are so critical to this are how it actually does that. So the only relief that would be provided, and I think everyone agrees, and I noted in here the study that was done by the Carsey School, the Dartmouth study, also the National Parenting Group that gave the state of New Hampshire an F. We pay the 3rd highest amount in the country. We pay $1,000 more than the average. So you have all these available studies. The previous study that was done that was sanctioned is similar to the study that's coming up at the end of this year, which is another study. This has been the previous attempts at this were were Bill 228 and 161. Both of them had suffered the same fate. This repeating the same thing over and over again, expecting a different result is kind of that definition of crazy. But in this case, we have actually it's been identified that we are the third highest amount, pay $1,000 more. But what's really happening is all those funds go to one household. So we talk about the higher earner versus the lower earner and our ability to parent effectively. We all agree that 50 is the way to establish parenting time. But what happens is all of the funds go to the lower earning parent. That means that any decisions, and all of these decisions that came in here, which 431 proposes to turn over to the judge, are already burdened courts. I have to go to court on a regular basis to try and advocate for my family, for my 2 daughters. But what it would do is take everything that we talk about that currently are decided by the lower parent. Our current guidelines, 431, would do the same. All the decisions of how those funds are spent could be brought into court. So anytime there's a disagreement, there was some interesting testimony by Jay Markle, who's, I think, well known to this group as well. It talked about, it says it right here, vacations, entertainment, electronics, everything that would be subject to the courts. So that means every time there's a disagreement, it can be brought into court. We keep talking about mediation. That's for certain few people that can actually qualify to go to mediation, that they're already in agreement. If people are getting divorced and they're separated and their families are split, there's usually more disagreement than agreement. So in most cases, they are going to court, and this would actually allow, anytime there's a disagreement, a disparity between 2 households, you could take that to court, the higher earner or the lower earner. I jokingly say in my testimony that qualified as popcorn. If one family gets popcorn, the one parent pays for popcorn, the other parent has to pay for popcorn. Is there butter on it? Is there a goldfish at one house? The other house qualifies for that. That's entertainment. Television, everything falls into this, but that's what this would do. It's intended to provide relief. I think we all agree that any of these laws that are being considered are intended to provide relief to the current issue of Silva v. Silva because of the strict language that all judges have to follow, not mediators, judges, and everything that 431 would end up in court. So what 431 proposes is those people between 50% and 60%. That means that the higher versus the low earner has to be within that 50% bracket, that 10% of the actual amount of cases going through. What that means is if you're already, you have to be that 50% to be the higher earner. We all agree 50 versus 50, you have to be 51%. And that only goes up to 60%. If you go through and you look at my calculations, and I want to be very clear about what Tony Machamalo from the mediation group, from the working group had proposed, actually don't show after taxes. I have to pay the funds, and most higher earners have to pay after taxes. Then what his calculations do not show as well, and I have his calculations right here, is that the lower earner does not have to pay taxes on what is received. So any of these calculations provide a very biased assessment of current guidelines. So the relief would only be provided up to 60%. Where we really have the disparity and where this kind of the problem is for most parents is that the higher earner can't make any decisions, can't make any decisions as to the use of those funds. There is no agreement. That's why they're in court in the first place. Judges have to follow Silva v. Silva. It has not been changed. There's been no lower court. It is still precedent for all parents. So a couple quick points, and I'd love to answer some questions, is that the subjective nature, I think everyone agrees we want bumpers. That was an analogy that was used by 2 of the folks that spoke before me. We're looking for guidelines, something that we can all hang our hat on, that judges can hang their hat on. What 431 would do would make it the Wild West. Every time there is a disagreement on the disparity between households, it would allow that to be heard in court per this law. It allows the lower earner the same thing that we have now. They will have all the funds. There's no relief to Silva v. Silva. And it actually worsens it. I want to make a very good point about this because this is what was discussed before. And then this is on section 9, Roman numeral 9. And I want to be very clear about this because this is law, and this is what people reference. Laws, not mediation groups, not agreements, not conjecture and happy feelings that people want to talk about. We are dealing with a real reality. And this is what's so important. If the net difference method does not meet RSA 458 C:5 - lowercase a, Roman numeral 2 criteria, the court may order the child support guidelines amount or another amount that does meet the criteria in RSA 458C:5. What that means is that it allows the judge, it allows the courts to be raising our children. It does not allow the parents to make any decisions. I cannot, and any parent, the higher earner, since this, is in an indigent state. There's no ability for me to allocate funds for secondary education, for savings. All of the funds, and this is the reality, not conjecture, go to the lower earning parent. What 458C would do is make everything subject to that, subjective. It allows the judge, and again, has to go to court. Our courts are already overburdened. They're already overwhelmed with these things. These cases go on, and in my case in particular, which is very relevant to this, every one of my orders says Silva v. Silva because of Silva v. Silva. There is no relief. No judge has the ability, doesn't have the tools. They don't have the tools to do the right thing. They have to follow it. Yes, if it's a mediation, if people are fortunate enough to qualify for mediation. But what 458C would do is turn everything into conjecture, subjective. And I think the worst part about this is that everyone's stating that 50-50 parenting time is equal, but they're not willing to let that be the case with the parents. And I want to be very clear. In the current Silva v. Silva, and what 458C would propose, is that the higher earner ends up with inadequate amount of funds. And I know it sounds bizarre, and I share my calculations with you there as well. The higher earner cannot pay for anything, has no funds left. Parents living in the fire barn because they're firemen and they have to pay all their funds. The higher earner having children that have to live in their vehicles with them. It is happening because the higher earner has no funds. And I want to be clear about this. It actually promotes the lower earner from not having to work. It promotes division of families because the lower earner, and every lawyer and everyone, as we are all discussing right now, is very aware of Silva v. Silva. It promotes the lower earner to actually say, well, I can do my calculations and this is what funds will be available to me. It actually promotes disunion of families. And there's a lot of talk and mention of, the abusers that are there are using these funds to somehow control the lower earner. I want to be very clear. A parenting plan is established in advance of any USO, Uniform Support Order, that comes from the judge. The parenting plan is based on the two affidavits. The parenting plan, whether parenting time is established far in advance and separately from the actual Uniform Support Order, which is the financial amount that's ordered by the court. That's done in advance. They do not relate. They do not intertwine. There's no way for one to affect the other. But what really is happening, it's in what I had handed out, is we pay the third highest amount. There was mention of Title 4D. People say that this somehow will affect the lower earner. There's other laws, as we all know, that are being considered at this time. None of them would actually reduce the amount of funds paid. They would actually just change how they are allocated. And currently, I think we all agree that funds due to Silva v. Silva go to the lower earner. That's the law. That is what we're dealing with. And I just want to add, the last thing is that if you read through these things, and I just want to hit some of the highlights of them, because this is where the kind of, and I'll say it, absurdity of this 431 comes into. If you read vacation, summer care, extracurricular activities, travel, entertainment, vacations, and people can translate vacations however they like, and the question was asked, February vacations, summer vacations. If one family does go to Winnipesaukee, the other family, per 458C, and it's very clear, can actually pursue the same thing and that disparity. And then it all comes down to Roman numeral 9, the court may order child support guidelines amount or another amount. So this, again, everything goes back to court. The other laws that are out there or legislation that's being proposed actually provides solid guidelines that the judge, that all participants can follow. It doesn't make it this kind of Wild West that 458, with its good intentions, still does. So, and I wanted to mention something. When the working group came up with this, there was a question as to why it didn't follow the Carsey study, why it didn't follow the national averages, and also why weren't parents allowed to participate. There's a Bill Woodbury who's from the New Hampshire Bar Association. He's on the parent working group, but I had asked all the individuals in advance of this outcome to participate, and I was not even responded to. And it's kind of a bizarre, closed, creation that was devised by people that are not really living this day to day. A mediator doesn't see what really goes on in court. Some of the discussion was based on things that were from the 80s, not from what we're dealing with today. So I appreciate everyone hearing me out, and it's obviously a very sensitive subject because many parents, higher earners, mothers and fathers are living this every day. So thank you for your time.
Are there any questions? Representative Yochello.
Thank you. And thank you for mentioning the parenting time, because that was the question that I forgot, that the parenting time is actually decided elsewhere and has, and so my question is do you believe that the money aspect should flow directly from what the parenting time was decided to be in the best interest of the child? So the money required to be able to support that parenting time should flow directly from that decision?
So
And
what
not-
the problem with current guidelines, 458C, equal or approximately equal parenting time is not grounds for deviation by itself. So if there is 50-50 parenting time, which everyone agrees is the norm, yes, that should. So currently 100% of all funds available go to the lower earner. Of course, if they're with me 50% of the time, I'm going to have those expenses. And everyone's right, when you have two different households, there are more expenses than just having the one. The sum of the parts is greater than the thing itself. So yes, I do.
Thank you. Can I follow up?
Follow
Or
up.
kind of a new. For the discussion regarding these variable expenses, it is your understanding in the reading of this that if people do not agree ahead of time on who should be paying for these variable expenses, you may be able to go to court and argue that you need a deviation from the normal guidelines because of whatever these variable expenses are not covered under the normal guidelines.
That is correct. So this would solidify, turn Silva v. Silva into law. And what that does is still only for the 50 to 60% would provide relief for anyone that's over that 50 to 60% area. Anyone that's only 10%. So everyone else would actually still have the lower earner receiving all the funds available. And in addition to that, the lower earner could then go and say, well, popcorn, vacations, flat screen TV in one home, driver's licenses, car insurance, things that are supposed to be the parent's decision, not the court's decision. And again, agreement. If there is disagreement, people have different parenting styles. People have different ways they like to raise their children, not allowing them to have devices, not allowing them to watch TV all day. None of that would be allowed with 431. It would turn all of that over to the courts. The courts would be parenting our children because everyone would go to the courts immediately. They could say entertainment, electronics, a television. Those things are all conjecture, subjective. We're looking for something that actually provides real guidelines that puts us in line with the rest of the federal standards, that puts us in line with the agreed to, which is 50% parenting time, is best for children. This would turn into the Wild West, and it would further send, and I say it in my written testimony, these children are in the abyss right now, and parents have to spend all their time, if they have any, or have any money available, to keep advocating for their children. Because this is about the children, not about some money factor. But in most of these cases, the higher earner has no funds available. So thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
So I'm going to close the public hearing on Senate Bill 431. Before we start the next bill, first I want to apologize for running so late and keeping people waiting. Secondly, not to embarrass anyone or anything, but if I could ask Miss Sanchez to just introduce herself briefly to the committee. I saw her come in. Miss Sanchez is going to be filling the shoes of Moira O'Neill in the Office of the Child Advocate. So welcome to Children and Family Law. We'll see a lot of you, I'm sure. Thank you. Okay, now I'm going to open the public hearing on SB 458. If you just hand it, they'll hand it down. And I'm going to call up Senator Gary Daniels to speak in the support of the bill with reservations. Oh, and by the way, the new bill that was handed out for 458, that was because there was no fiscal note attached to the other one. So this one, they wanted to put in the significant impact. Thank you, Senator.
Good morning, Madam Chair, members of the committee. For the record, my name is Gary Daniels. I'm a state senator from District 11, representing the towns of Wilton, Milford, Amherst, and Merrimack. Also the prime sponsor of Senate Bill 458. When we passed the budget last year, House Bill 2, there was a section of that that created a study committee to talk about the closure of the Sununu Center. And there were 5 people appointed to that, 2 members of this committee, including myself, and I chaired that committee. What you have before you today is not what came out of that thing, and that's why I'm testifying in support, because I know something has to be done, but with reservations, because what we ended up coming out with is an initial report. What was changed in the Senate with the amendment that you have before you. There were 3 primary things that we were directed through House Bill 2. Number 1 is that we're looking for a residential type field. That was the feedback that came back from those people that appeared before the study committee. They wanted a residential feel inside and outside, not an institutional look. Secondly, that the closure date was March 1st, 2023. Aggressive, yes, but I think the majority of us felt that it was doable, and it put out an incentive there to not let the thing be delayed. And thirdly, the size of the facility needed to accommodate 18 beds, and that's because not because you were going to have 18 people there, but because they needed to be separated by gender, they needed to be separated by needs, and others. So it was just necessary to have that type of accommodation. I have sent a link to each of your email that will give you the information from the study committee report, including the final one. I will say that there's quite a lot there, so you can use up your weekend on that. So there, in the interim since then, they've come in with a new amendment which proposes building a new facility on yet undesignated state land. There's been talk about making the facility smaller than 18 beds. There's also been a lot of talk about how using residential, and I'm talking more private residential, because I think we figured with the March date that we had, you didn't have time to build a new facility. So taking what was existing out there now and accommodating that. We've heard a lot of feedback about how a lot of abuse happens in private residential. I guess I would counter that by saying we have $100 million worth of suits and counting that came out of Sununu, and that was under state control. So one of the things that kind of raises a question in my mind is that are we giving HHS so much responsibility, and we know that they have loads of people, vacant positions. Are we putting so much on that department that they haven't got the ability to oversee the things that need to be done such that these things are happening? And maybe going in the direction of a private, it allows you to have personnel to take care of that. Still going to be under HHS oversight. You know, we want to control, so they're going to have to control. If they want to contract with us, they're going to have to go according to the contract that's set up. You hear about non-disclosure acts. There's no reason why something like that can't be built into a contract, so that when you're contracting with a private concern, that they know if the state comes in and says, we want to inspect this, we want to investigate this, it's a done deal. They can't back out of it. Now, I'll get toward closing to say that HHS contracts all the time with private concerns. I mean, many programs, because we don't do it all as a state. We go out and we take those organizations and those agencies that can do that, and they specialize in that. And so this is not setting anything precedents by going in this direction. We do believe that we ought to be getting out of Sununu as quickly as possible. And that's why, you know, I tend to prefer the March 1st date. I know that there was some consternation in there because we said that if the facility isn't built and ready to take the youth by March 1st, that the bill had said, the original one had said we would put them out of state. I would have no objection if you wanted to leave them at Sununu until it's done. But I mean, the way that this was amended in the Senate, it now actually allows you to drag it out another 2 years. And I think that's just way too long. HHS has a program that they're ready to put in place, and the sooner we can get that going, I think the better it is for all of us. Thank you, Madam Chair.
Are there any questions for the senator? Representative Belanger.
Thank you, Madam Chair. Thank you, Senator, for being here, and thank you for your testimony. Just to clarify, having been on the commission, what were the 3 recommendations that came out of that commission?
Three recommendations were, one of them to use the private residential. Secondly, to build a new facility somewhere on state land, which would require at least 10 acres. And thirdly, to modify Sununu Center to make it smaller.
Thank you. I just wanted that clarification.
Representative Yokella.
Thank you. Thank you for taking the question. So you said you supported it with reservations, and it seemed from your testimony that your major reservation is that they could drag it out for 2 years. Is that correct, in my understanding, or is there more things that you are concerned about in the current language?
That's one of the reservations. The other reservations I have are, I don't know that we need to spend the money to build a new facility. I mean, the Senate did take out the $15 million appropriation on that because, frankly, we ran out of time and didn't have the time to come to a final conclusion on doing that. But thirdly, I think some investigation needs to be had to determine whether or not this should be something that is directly overseen by HHS with the track record we had with Sununu, and make sure we don't overload our staff, and the ability to access other private concerns that do these things all the time. So I think there are other options that are out there rather than going the direction that we did.
Are there any further questions? Seeing none, thank you very much.
Thank you, Madam Chair.
Up next is Rebecca Ross and John Williams. to speak in support of the bill, and they need 10 minutes.
Madam Chair and members of the House Children and Family Law Committee, for the record, my name is John Williams. I am the Director of Legislative Affairs for the New Hampshire Department of Health and Human Services. Wow, that was quick. I can talk fast, but not that fast. And with me today is
Good morning. Rebecca Ross, Director of the Bureau for Children's Behavioral Health, and Director Ribsom from DCYF is unable to attend today, so we're here on his behalf as well.
So Chairman Rice, I wanted to thank you up front as you being a co-sponsor for the bill along with Senator Daniels. And I think it's helpful just for document control to make sure that everybody does have the one as passed by the Senate. It will have 3 amendments, and the last of the amendments are 1272S. Fantastic. So the bill, if I can just give a very high level, less than a minute or two walk through the legislation, because I did work with the Senate leadership as well as Director Ripson on the drafting of the legislation. That Section 1 does articulate the building of the new secured facility. I do understand, starting on page 1 between lines 3 and 5, that we certainly want to honor the perspective of the sponsors for the bill, particularly around serving the 12 youths. That is the goal and the objective. And I would do have language prepared that I believe Representative Rice has been provided to you. If there's not enough time because of you having to get this bill completed before the 14th, the deadline for second committee bills, certainly we'd continue working with you moving forward as well on making those adjustments as you
It
see.
has to be out of committee today because we didn't plan on, right, because it has to be done before next week.
That was my clear understanding that you had to exec out on the bill today. So that was given the timing. I do have copies of the amendment at your direction that I could share with your committee.
Sure.
And if Ms. Ross, if you could help me with that. Thank you so much. And as Ms. Ross is circulating, Attorney Ross is circulating that, the key components here on the amendment is to identify the goal here is to serve an average of 12 youths at the facility. We do need, as Senator Daniels pointed out, sufficient space and flexibility to be able to appropriately separate the children on occasion by gender age.
Excuse me 1 second. Can everybody please silence their phones? I keep hearing phones going off, and it's just very disrespectful to the people speaking. Thank you. You may continue. I'm sorry.
Thank you. So what we would suggest for your consideration to substitute in the sentence that is found between lines 3 and 5 of the bill as it passed by the Senate to include the language. You'll see that the highlighted language in the draft that was provided to you is the additional language to clarify that we're seeking to serve an average of 12 youth, striking the word 18 beds. Continuing on with an additional sentence that you'll see that says, in order to accommodate for the individual needs of youth, including gender, diverse clinical needs, emergency separation of youth for safety and security, and the opportunity to provide space for crisis stabilization, the physical layout may have no more than 18 private sleeping rooms for youth. And we do think that that clarifies and honors the concern regarding the use of singularly of the 18 beds. And again, that's for your consideration and can certainly address questions regarding this section before moving on to other sections, or I can keep moving along.
Does anybody have a question? Representative DeSimone?
Thank you, Madam Chair.
On this part, right?
Yeah, on the amendment. Okay, so I agree so far, but underneath the bolded type, it says that the department shall consult with any prospective community about the location and operation of any new 18-bed facility. Should that be changed to 12?
And that actually is in the bill as it came over from the Senate. I believe that our goal here is to preface in the very introductory section here that everything following that for any reference to 18 has to acknowledge the fact that it's to serve 12 children. the 18 beds is just to allow the flexibility to serving those 12 children.
Thank you.
Representative Belanger.
Thank you, Madam Chair, and thank you, Mr. Williams and Ms. Ross, for being here today and presenting this testimony. In regards to this, and I do see this in the bill, so I will address that. To Representative DeSimone's point, the department shall consult with any prospective community about the location and operation of a new 18-bed facility. It brings me to my point. And I will I'm just prefacing with the question: we're consulting a town or community if they're okay with an 18-bed facility coming into their backyard. I can name, what do we have, 200 and some odd towns that will say, no. Would you agree that you find that to be a problem as well?
Happy to take that. It appears John is looking to me. I think the way it's drafted is that we will do our best to work with communities. However, for state facilities on state land, it's not the same zoning process. So while we'll collaborate, I don't think that automatically means that each community is going to be able to say no, and we will be left without a place to site the facility. Similar to the way it's working with acquiring Hampstead Hospital, we're very much working with Hampstead on that transition, but it will still be a state facility within the town.
Are there any further questions on this amendment? Pardon me? Do you have a question? Okay, yep, Representative Grossman.
This is proposed.
Right.
This
the
is not an
proposed.
amendment yet.
I'm
though,
sorry, right, yeah, it's
Okay.
proposed. Are there any other questions? All right, seeing none, please continue.
Representative Rice, thank you. That then takes us, as you can see, Section 1 of the bill is set up as chapter laws, and it has individual Roman paragraphs, so we've now covered paragraph 1. Paragraph 2 identifies that the department has an obligation and shall issue a procurement for a qualified design build architect on or before August 1st of this year. And the following sentence identifies that we are looking to, as part of that, to complete the project on or before June 30th of 2024. Under existing laws, we know under HB2, the date for standing up the facility is March of 2023. We do know the realities of building and having to do this appropriately and doing it the right way, that the bill is coming before you for your consideration to setting up a design to allowing us to be successful, not only in setting up the facilities, but as you'll see in the next sections, to identify the correct approach in terms of not only building design, but also the programs and staffing for those facilities. So that quickly takes me through paragraphs 3 of the bill, which sets forth the design requirements for the building. Representative DeSimone, to your point, there is another reference to the 18 beds in here. However, with this amendment, that would cover us because it comes before explaining exactly why the 18 beds are there, not to fill them, but to give flexibility. Moving along to section 4 of the bill, these are the programming operations, and this is really critical. And I think the advocates that you'll hear testifying in support of this bill are going to identify that these are components that are really necessary to appropriately address the youths that are going to be receiving services through the facilities. You have the staffing qualification standards, you have evidence-based practices, utilization of uniform assessments, provision of care management, visitation opportunities for family members, educational programming and staffing, integration of clinical assessments, and to our new child advocate who is here with us, real-time access by the Office of Child Advocate. Section Roman 5 of the bill talks about standing up at least the first 2 provisions of these programs so that there would be a seamless transition between the existing facility, which is being closed on March 31st, or rather March 1st of 2023, and then the standing up and opening of the facility, which is slated for June of 2023 currently. So, and as set forth in this bill. So the department also has quarterly reporting requirements. And I will say Senator Rosenwald had a very good hand in making sure that she identified certain particular factors that she needed to have, wanted to have the legislature, you in the House also reported on. And you'll see going to page 3 of the bill that there's outlined subparagraphs A through E that give very detailed data-driven information in terms of the progress for standing up the new facility. Paragraph number 7 would give the governor the authority to go to fiscal committee, the joint fiscal committee for both the Senate and the House members, to seeking as needed if circumstances unforeseen were to arise, the ability to come back before the legislature without having to file a bill like this again to go back for your body to move forward on the construction if there is a need to extending the time for building. The thoughtful approach here, and I have to give credit to Senator Bradley, is that it does prevent us from every year having to come back here before you on a bill if there is a need to making certain adjustments based upon materials, based upon location of facilities, based upon, as Representative Belanger pointed out, citing specifications and communities that there could be unforeseen, but we'll make best efforts to accommodate these requests, which brings me to to accommodate this request, you have to have an appropriation. So if I could direct your attention to page 3, line 21, you'll see at the very end of that first sentence on that line, it says the sum of $1. If you could add a 5 followed by a comma and 6 zeros, that would be particularly helpful. That's $50 million. As Senator Daniels pointed out, it wasn't the Senate's position to tag the department with $1. They knew this was going to cost something. They just needed the additional time to allow the process to work out through the House to identifying what that amount should be. As you'll see from the fiscal note attached to the bill, it's based upon the commission that was established in HB2 for the closure of this new center. And on page 126 of that report, you'll see that the Department of Administrative Services, through Commissioner Arlinghouse, identified at that time while looking at this, the bricks and mortars piece of this was estimated at $15 million. So that's where that amount of money was derived from. And you could certainly reference back to that report on page 126. So yes, 15 million. If I spoke higher than that, that's only because we had delusional wishes in the department for $50 million. But I think I hopefully said 15, 1 5, followed by 6 zeros. You'll see on section 4 of the bill talking about a repeal. Those are specific sections in HB2 with timing for standing up the facility. Obviously, those need to be taken care of. You don't want 2 laws in the same with different dates. So those would repeal the provisions in HB2 for the standing up of the facility on March of 2023, and then the effective day after passage. I hope that was a meaningful walkthrough of the legislation to give you a full depth of understanding of what was accomplished in the Senate. I think they did a wonderful job with the bill, and we are here certainly to address questions. But before I do that, I want to ask Director Attorney Ross if she has anything to offer.
I don't. I'm happy to take any questions and help explain how this integrates in with the children's system of care that we've been working on as well.
Okay, so before I call on people to take questions, I'm going to take a little privilege here and say that I think that if you're a co-sponsor of a bill and it's gutted in the Senate, you should be able to ask a ton of questions. So I need to figure out how we're going to fix that because I have a ton of questions that I can't ask. So the people that can ask questions, Representative Grossman, go right ahead.
Thank you, Madam Chair, and thank you both for coming before us today. I have one question related to what happens to the youth on March of 2023. So the facility is closing, but the new facility is not ready yet, right? So where are the youth that are in the Sununu Center going in that interim period?
Having not been involved in the last couple conversations, we would have to ensure that they are in a secured setting during that transition period. It's required by their court orders and their detention or commitment status, and we would need a seamless transition that they are not left without a place and without supervision during that period of time.
Representative Yokella.
Thank you. And thank you for taking the question. I think it's HB 254, we're changing what people can be committed. If that law went into effect, what would be the current population of committed individuals?
We don't believe that that will have a substantial impact. There are ebbs and flows through the population throughout the year, and at any given time, we don't think it will have a substantial impact. And so we would still need to be able to ensure that at the highest level of need, we're able to meet the capacity requirements.
Follow up.
It's actually a different question, but
Oh,
my
different
my the question on page 3, line 12 to 14, it says the governor, with the approval of the fiscal committee, can extend the deadline. If the fiscal committee says no and says we want the Sununu Center closed ASAP, we're not extending the deadline. What would the department do?
I think we'd be working very closely with the Attorney General's office and going to court in every single case where a judge has ordered that an individual be securely confined, and either looking to move them out of state or find an alternative plan. But it would create a substantial crisis for those youth that are not ready to transition out.
Thank you.
Representative Long.
Thank you, Madam Chair. Thank you for taking the questions. What the first question is on the first page, line 16 says you'll be completing the project on or before June 30th, 2024. So that's 2 years from now. And then you extend another 2 years if fiscal committee doesn't, on page, page 3, starting on line 12, unforeseen circumstances provide any such delay be no more than 2 years. So that's a potential construction industry in the state of New Hampshire. I'm looking at 4 years to get this done. That's unacceptable to me. So I guess I need to address that whenever I address it. This
We
is
would
what you're
believe.
agreeing with, so I won't ask. And just one more, if I may,
Sure.
Madam Chair. The implementation of it starts page 2, line 4, all the way down. The implementation with while children remain at the current facility by March 1st of 2023. How do you see that? How do you see that working? I mean, it seems like we're doing something we've been doing forever. And then now we're going to change that so that when the other facility's ready, we move in ready to go, is my understanding. How does that get done?
I believe that the language for standing up the facility for June is on or before that. So it would be a seamless transition, as Ms. Ross had explained to a previous question. That would be our goal, making sure that the appropriate staff were set up. Which does raise one other question I would want to point out to committee to be fully clear about the cost. The 15 million is for construction. It does not include the staffing and other resources that are going to be needed that will have to be built into our 24-25 budget.
So you,
Follow-up?
yeah, you, my question was how you do it. You said that was your hopes of doing that. That is your goal. My question was, how do you get that goal? Especially where current staff members probably need different qualifications, I'm thinking. So you gotta raise that money. You gotta go to fiscal to get that money to change by March of 23.
Yes, and there's already been work on changing the job descriptions for the staff at SYSC and changing the operations so that that's in line to move into a new facility. There are a lot of details to be worked out, but until we have more than $1 in an actual plan, there's only so much that can be done to make those. But the goal would absolutely be to have staff trained and in the new positions and roll into the new facility. And look at the lessons learned from moving into the new women's prison and other facilities, and work with the team that's moving and building the new psychiatric facility so that we can get that seamless transition and have everyone in their new roles at the time that we transition into a new facility.
Okay, thank you.
Representative Yokella?
Thank you. Thank you for taking the question. When you talk about changing people's roles, I assume that you're talking about current staff changing their role, because it wouldn't be a change unless they weren't current. So what is the benefit of moving to a different facility if the staffing is the same, as far as the people, or are we reducing the number of people that we are going to staff it, or increasing? How does that, is there an actual benefit to moving if you're keeping the same people?
And
Yes.
Representative Warice, respectfully, the legislature has already drawn that directive to us to close down Sununu as part of the HB2. So it's an interesting question, but I think it's moot only because we're already under state law to close the facility. So we do have to do that. And I believe, Representative Yokella, we will continue to be very thoughtful to make sure that as it sets forth starting on page 2 on line 4 on Roman 4, that we have appropriate staff, and not only appropriate staff by standards and qualifications, but also the programs that we're going to be providing to the youth that are going to be at that facility.
And to add to that, we are looking at the right array of staff. And in a very large building that we're in now, that's going to look different than in a smaller space that's configured differently. We can't completely design that until we know what we're going to be moving into. But the A&M report that was provided to the committee and used over the summer helps lay out and define what the appropriate staffing would be to move more toward the system of care and providing a different clinically based approach as compared to where the SYSC facility is operating now, which has substantially changed in recent past, but is going to continue to evolve with the movement into a new facility.
You all set? Representative Belanger?
Thank you, Madam Chair, and thank you again for being here today. As the only legislator who has been a resident of the facility, I do have a couple of questions. You stated that HHS, Ms. Ross, that HHS has got a lot of projects on their hands right now. How is this going to impact those other projects? And do you see this being another project on top of the other ones that you're dealing with? Do you see that being a problem?
Provided we have the staffing and the resources to construct a new facility and train folks to move into it. No, I think that's how we scale our work, and we're able to do it. Projects and processes always change. That we're used to those adjustments.
And Representative Rice, if I could just add to that, we, in addition, that's why I pointed out that the $15 million is really a capital budget for standing up this facility, which is needed. And we are thoughtfully working through, we're already part of the development of the state agency efficiency phase of the budget. So this is certainly a priority for the department and something that we're going to be thoughtfully working through in terms of those resources.
Follow up?
Less of a follow-up, but an additional question.
Sure.
Regarding census. So I have 3 questions regarding census. What's census today? What was census last week? And what was census last month total?
Yeah. The last I knew, as of some point last week, it was 12 or 13. I can get you those and follow up as soon as I get back to my phone and make an ask of that. But it has been ranging around that 12 for quite a long time now.
Follow up?
I do have a follow-up to that question and one more following. So Representative Yokella had alluded to HB 254 and what changes would that affect the census. Just to clarify, in your statement, you said based off of HB 254 and the number of 12 youth that are in that facility, you do not expect there to be a drastic change.
No, not a substantial change. That doesn't mean it won't have an impact on individuals throughout their cases, but given how far we've reduced the census over the last decade, And the things that we can't predict as a result of 254, whether it be that additional youth are prosecuted into the adult system who end up spending a longer time there during the certification to be prosecuted as an adult during that process, we don't know what those impacts will be. So we can't predict that there will be less youth there, less days based on House Bill 254.
And last question, Madam Chair.
One more.
Thank you. So, Mr. I'm sorry, this is the first time I'm seeing you. What was your name again?
My name is John Williams, and believe it or not, I started in front of this committee back in 1999.
I apologize. Very nice to meet you. Apologies for not getting to that originally. Mr. Williams, so in your estimation, the 15 million is expected for construction only. Is that correct?
That is correct, as you'll see identified on page 126 of the commission report.
Just following up, Madam Chair.
126.
Yep. So in the bill itself, it states that we will construct a secured treatment facility that is no more than 18 beds, and we did talk about the amendment here. However, as studies continue to show, we expect a more home-like environment. Where is this in this bill where my expectation is that we are supposed to be building a more home environment and less of a prison? Excuse me, youth detention center. Big difference.
Deferring to Ms. Ross, because this is more of her world of subject matter, but as you see built into the bill, and again, working with the advocates very thoughtfully, because the not only the department, but the community that supports children and healthy environments for those children, identified as part of the language of the bill in paragraphs 3 and 4. Not only the facility, how it was to be constructed, but to get into the details of the types of programs and how that would be managed to ensure to address the concerns that you're raising, Representative Belanger.
Thank you. No more further questions.
Are there any other questions? Representative Altschiller?
Thank you, Madam Chair. Thank you for being here. And I'd like to go to page 2, line 9. Section 4B, under the facility programming and operations shall include, under B says use of evidence-based practices as defined in RSA 170. And I'd like to know why we are not, why we focus in specifically on evidence-based practices when some of the newer research coming out is telling us that evidence-based practices have limitations in that they are very unless that evidence-based research that then results in a practice is done with an eye towards a broad-based application of youth. We're seeing a lot of this evidence-based research coming through highly targeted. And would it not be in our interest in New Hampshire to have evidence-based and research-based practices as part of this RSA to allow for the flexibility for programming to not be structured in a way that inhibits the growth of that programming?
Absolutely. I completely agree that using exclusively evidence-based practices prohibits the expansion of the availability of evidence-based and evidence-supported practices. It's consistent with the system of care. We are certainly looking to grow that world of services and make sure that evidence-based practices are used with fidelity so that you're not using an evidence-based practice with the wrong population to not get the outcomes that you want. So looking at evidence-supported or research-based in the inclusion of the service array is certainly important as we're growing.
Follow up?
So if there were to be a change in that to use evidence-based and research-based practices, would that be something that would be supported?
The department would support that. It's consistent with 135F in the system of care, and it would help support the progress at the facility.
May I follow up?
Follow up.
Above that, facility programming and operations, Part A, staff qualifications and standard job descriptions. an emphasis on treatment with youth with behavioral health challenges and considerable trauma histories. It says applicable to the facility. So could you explain what that would be? Because I do not understand how that could be. Is that saying, is this another way of saying training that emphasize the treatment of youth with behavioral health challenges who are in the juvenile justice system, or
Yes, and we would include
without actually saying that?
Well, this is focusing on the operation of the facility, but we want complete integration with the system of care for children. So they're getting engaged with the care management entity while they're at the facility in order to ensure an appropriate discharge plan and transition into either community-based services or residential care as they're moving out when appropriate. So we would expect the same CAT assessment and CANS assessments to be used and to integrate that throughout their service delivery.
May I follow that up? So in part C, the utilization of the uniform assessment, I think if you could point out for us where our stated goals in doing these reviews was to provide for the children who have experienced every child who is coming into our facilities have an ACEs score of 7 or higher. That's just flat out. That's it. So how are we addressing their ACEs scores while also addressing the juvenile justice aspect? So where is the treatment of coming up out of that simultaneously with the juvenile justice aspect? Because we have leaned a little too heavy in the juvenile justice and not addressing those ACE scores.
So I think they really are one and the same. In order to provide treatment and supervision and ensure a safe and appropriate transition back to the community, you have to do that. Every youth at SYSC is now getting the CANS assessment. The staff down there have been trained. That's the same child and adolescent needs and strengths tool that's being used by our community providers and our residential providers and within our acute psychiatric facilities. So every 90 days, that strength and needs assessment should be completed. That's part of the CAT assessment, which is looking at level of care for residential, and all being integrated into their short and long-term goals that are approved by the court system every 90 days through Family First.
Are you all set?
For now, thank you very much.
Okay.
Yes.
Representative Lebec?
Yes, thank you. So on page 1, line 27, it talks about the space to meet the educational needs of the youth and youth with special needs. Would that space include like private areas where they can have tutors or the staff go over like homework, and so that way they're in that area and there's no distractions for them, because some kids need that extra help?
Absolutely. Currently, SYSC has a full school with multiple classrooms and a very large space dedicated to that. It's too much for the 12 or so youth that are down there. But we didn't want to end up in a home-like setting that didn't have that ability to fully educate. So we would expect there to be classroom space, tutoring space, and the availability to do assessments and meet with educational professionals for every youth that's there.
Are there any further questions? Representative Yokela?
Hi. Thank you for taking the question. On page 2, line 4, it says that the programming shall include, but it doesn't say it's limited to this list. So would you be able to use the research-based things now without a change to this legislation?
Yes, I mean, certainly it doesn't say use exclusively evidence-based, but if the legislature wants to call out that we as a community are going to support the research-supported practices as well, that gives the facility and the staff better direction as to the intent of the legislature in standing up the new facility.
Are you all set, Representative Yokela? Representative Belanger.
Thank you, Madam Chair. Just a really brief, going back to my census question, kind of popped into my head. How many are misdemeanors that are detained? That are back up. In regards to the number of 12 youth that are currently at SYSC right now, how many are misdemeanors? How many are felonies? How many are detained? And how many are committed?
Yeah, I mean, that changes every day. We would have to go back and get the list. I know we've provided that information before. I think what can be deceiving is that currently under the system, if law enforcement and the prosecutors know that they can get the outcome, there is a high willingness to work with the parties to reach a settlement that the youth can be committed to SYSC or held at SYSC. And so there are plea agreements or settlements for a lesser offense, even if you look at the underlying facts that may be higher. So even if it says misdemeanor today, it could be a felony level behavior or conduct that may in a future system, in fact, be prosecuted as a felony or as an adult felony charge.
Follow up?
Just if we could get that as quickly as you possibly can, that would be greatly appreciated.
We will ask for that and send it over.
Are there any further questions? Seeing none, thank you very much.
And thank you, Representative Rice.
Thank you.
Up next is the Honorable Neil Kirk, who is in support of the bill as introduced and opposes the bill as amended, and he's asked for 3 minutes. Good to see you, sir.
Good to see you, ma'am. Good afternoon, members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm representing myself. For many years, I was a state representative and served largely on the Finance Committee. This committee, for at least a decade, has been working toward treating children in the community and not in an institutional facility. I finally glommed onto that in roughly 2016 when I realized that the population of the Sununu Center was declining significantly, and we were spending a lot of money on a building designed for 144 when in fact it was occupied by 60, went down to 40 to 20, and now we're at 12. And so there was a confluence of advocates for community treatment for people, and those people on the Budget Finance Committee who were concerned about paying for this, that met. And we've been working for years on this project. You folks on this committee have been working to have children treated in the community. House Bill 254 is the latest iteration of that. And folks on finance have been trying to figure out how we can reduce the cost. One of the problems with having an institution is that you have fixed costs. Whether there are 144 kids or 12 kids, this is an exaggeration, the staff is significantly the same. For example, there are 83 staff members today at Sununu. Under this bill, as the Senate proposes, the 18-bed facility, there would be roughly 63. Okay? A huge number of people for a relatively small number of children. Right now, we're spending $1 million a year per child in Sununu, over $1 million. So I oppose the amendment that came out of the Senate and support the bill as introduced by Senator Daniels and Representative Rice. The bill that came out of the Senate, the bill that you have before you, repeats history. It creates a mini Sununu Center, 18-bed, 12-bed, a mini Sununu Center operated by the state at least historically on a reform school model rather than a treatment model. That certainly was the result. And we have seen what has happened. Hundreds of millions of dollars in lawsuits as a result of mistreatment of these juveniles. And it's unclear whether or not, at least to me, you folks probably would know better, whether the treatment the children received, forgetting about the abuse, but the treatment they received really benefited them at the Sununu Center. The idea that we would pass the Senate bill suggests that we have learned nothing from history and we want history to repeat itself. Do we expect another couple of $100 million of lawsuits 5, 10, 20 years from now? It's a bad approach. It's not child-centered. It's not treatment-centered. The bill is introduced, the Daniels-Rice bill, took a different approach. It said basically, we're going to provide treatment in the community in a nonprofit, private sector run facility, which might, by the way, if it's done correctly, make the children eligible for Medicaid cost sharing, which is not the case now at the Sununu Center. One of the advantages of doing this is that the costs to the state are variable. Instead of the fixed cost, and by the way, this bill doesn't talk anything about the operating expenses, roughly $9 to $10 million a year, in addition to the $15 million construction cost. If these children are in a community facility, then we pay per child per day, a saving of roughly 1/3. If there are 3 or 4 children, the cost to the state will be $4 million a year. If there are 6 to 8 children, the cost will be $8 million a year. If we go with the bill as it came over from the Senate, we're hit with a fixed cost of $9 to $10 million a year, regardless of the number of children. And if 254 passes, I believe there will be a significant drop in the number of children who are need treatment in Sununu or the replacement facility. So the bill is introduced, puts treatment at the center in a private nonprofit provider secure facility that just might be eligible, as I say, for Medicaid cost sharing. I urge the committee to reject what the Senate has proposed and come up with what the Senate chairman and your committee chairman originally proposed, which was child center, treatment center, and cost effective. There's no reason to do anything else. And by the way, I understand you have a deadline. If you don't have an opportunity today to make the tweaks that are necessary to the original bill, my understanding this bill is going to House Finance. And I know some of the folks on Division 3 there are very sensitive to this issue and will be more than accommodating to the committee if the chairman would approach them and say, we didn't have time to do A, B, and C. Please tweak the bill on these policy issues. Thank you, Madam Chairman. I'd be pleased to answer any questions.
Thank you. Representative Belanger.
Thank you, Madam Chair, and thank you, Honorable Neil Kirk, for being here today. I've heard a lot of great things about you, and I apologize for not serving with you. So you alluded to Medicaid cost sharing. Is that correct?
Yes.
Where do you get that?
There are provisions in federal law that make a child who is Medicaid eligible ineligible to have his cost of treatment paid for, or co-share paid for by Medicaid, if he is in a public institution. And the Sununu Center qualifies as a public institution. There is an exception if the facility has less than 15 beds and takes in or makes available those beds to other children who are not necessarily in the same category. And depending upon how the department would contract this, we might find ourselves in a private sector nonprofit facility that has 12 to 16 beds, some of which would be available to non-committed type children, and therefore it would qualify for, or could qualify for Medicaid.
Follow up?
So if we could qualify for Medicaid, why aren't we qualifying for Medicaid now?
We can't qualify for Medicaid now, sir, because we have a facility that is a public institution as defined by the feds, and that immediately disqualifies the child from receiving Medicaid sharing for his incarceration costs. Moreover, that facility has a capacity of 144, and the maximum under federal law, I believe, is 16.
Follow up?
Final follow-up, but thank you for answering the question. So, of course, I didn't pull up the previous bill that was introduced in the Senate, but I do believe that it's still required for a secure treatment facility, which my understanding of Medicaid reimbursement is that it would not be eligible for reimbursement provided that it is a secure treatment facility. So that's where I question that we can do that. I've heard both sides of the argument say yes, and I've heard from sides that say no. So finding this information to its full extent and finding that statute and federal understanding would be beneficial in my decision-making process, because my understanding, and I don't have it in front of me, it says no, we can't. if it's privatized because it is a secured facility.
Uh, y- y- it's not the security of the facility, it's the fact that it's a public institution. There are people who will follow me in testifying who can add to this. And I have a piece, I hope I brought it with me, that I will share with you. I don't have enough copies for everyone, and I understand you have a timing issue, that you could read, and it might perhaps assuage your concerns. But I'd point out to you, regardless of whether or not Medicaid would cost share, the original bill as introduced is a better bill because it will save us money, even if we pay for it, as we do with the Sununu Center, with 100% general funds. So I don't want that to be, I don't want the Medicaid cost sharing to be a red herring. It's a possible bonus, but it's not the reason for going back to the original bill.
Are there Representative Long?
Thank you, Madam Chair, and Representative, I apologize for serving with you.
Apology accepted.
Okay, thank you. You mentioned for 12 years, at least, we've been going for community-based, correct? So how many facilities would there be, even if they're private facilities? So community-based means a Manchester resident would be in the Manchester area because that's their community. Aware youth would be in a facility somewheres within that community. Is that my understanding?
No. There would be a single facility provided by the private nonprofit located somewhere in the state, and both Manchester and Ware children committed to that facility would go there. There are other facilities which provide residential services today under the Service of Care program throughout the state. But that's very different from what we're talking about here. This is a single facility for this very small group of children who need a secure facility to both protect themselves from themselves and or to protect the community from themselves. That's the purpose of this bill. To
Okay,
replace the Sununu Center with something other than that.
Right. Follow up, if I may?
Follow up.
So community-based is not the case.
Community-based is not the case for this very small 3
Okay.
to 8 to 10, 12 children. You're correct.
Okay. Very good. Thank you.
Are there any further questions? All right, seeing none, thank you very much.
Thank you, Madam Chairman. Thank you, members of the committee.
Up next is Cassandra Sanchez to speak in support of the bill. She does have written testimony.
Hi. Good afternoon,
Welcome.
Chair Rice.
Welcome to the Children and Family Law Committee. It's so nice to see you
Thank
again.
you. Thank you for having me. It's a pleasure to be here. I'm hoping that we can continue to work together in the future. I look
And
forward
we
to
will,
it.
yes.
Absolutely. And so today I have with me the Associate Child Advocate, Emily Lawrence, to help answer questions, as this is only my third day in the role. She's much more of an expert on this bill as I am at this point, but I've done my best to catch up as quickly as I can. So today we are here in support of Senate Bill 458, as it has been amended. In the spring of 2021, New Hampshire took firm footing in transitioning of the juvenile justice system with enhanced resources, new pathways to diverting children from the system, and in House Bill 2, closure of the sprawling youth prison and detention center. These accomplishments brought New Hampshire into alignment with the latest science on child development, in particular brain development. We understand that there is concern about the size of the structure and number of beds proposed at the new facility. We do agree, and we did advocate for the language of no more than 18 beds. We would support amending the current language for fewer beds. Several initiatives that were considerably delayed but are now underway predict even less need for a secure detention center and confinement facility in the near future. Under changes being phased in from 2021 Senate Bill 94, pre-petition assessments are proving to be successful in diverting children from the system. Estimated reports of the first 2 months include 80 assessments completed. Preliminary data shows 70% have resulted in children being diverted from court. 20% have instead accessed behavioral health services such as multi-systemic therapy. 50% are accessing local community supports and traditional diversion programs. Furthermore, very recently, the court rules of probation or conditions of release were changed from 20 overwhelming limitations to just 4 and an individualized plan. Not attending school or not following curfew are concerns, of course, but we do not consider those criminal acts. Individualized plans for each child will address these behaviors and minimize the need for them to be in a secure setting. The office supports the adjusted time as articulated on page 1, line 13 through 16 of the amended version that provides the department until June 30th, 2024 to complete the project. The community and legislature have demonstrated a lack of trust in the department's plan, which to some degree is understandable given the ongoing criminal investigations. We feel that we must have confidence in the many community-based rollouts that are currently taking place, including the 2021 Senate Bill 94, allowing the assessments of need prior to the delinquency petitions being filed. Our impression is that a state-owned facility will provide the best return on investment and the most flexible use of the investment. As stated, page 2, line 25 through 28, by remaining state-run, the OCA has the ability to maintain oversight with access and ease to gain records and immediately respond when there are incidents within the center. Thank you for taking my testimony and allowing me to explain why we support the amended version of Senate Bill 458. I'm open for any questions. Thank you.
Representative Yokella.
Thank you. Thank you for taking the question. If, as the previous speaker suggested, we not have a state-run facility, would you and contracted that out, would you have concerns about that? Because it seemed like your testimony said that, or implied that your support was contingent on it being a state-run facility.
Well, we are in support of it being a state-run facility, specifically because of the ease of the Office of the Child Advocate gaining immediate access to records and having oversight within our access to the records via the computer system, the casework management system. So that just makes it and provides us more ease in getting access. We do still have oversight in any agency that is serving children across the state. So we would still have the oversight. It is the ease for us to gain access and to immediately respond when something happens, as we have seen with the Sununu Center. I think one thing that's important to note as well is that we have only been running for 4 years, so our oversight of the Sununu Center is very new. So although there have been many complaints over time, our involvement has not been with all of those complaints.
Are there any further questions? Representative Long?
Thank you, Madam Chair, and congratulations, Mr. Sanchez.
Thank you.
So on page 2, starting on line 32, August 1st, 2022, they begin reporting to the Legislative Joint Committee on Health and Human Services and to your office until a facility is operational. Should those reports continue to your office while the facility is operational?
We do feel that those should absolutely continue to come to our office, yes.
Okay, great. Thank you.
Representative Altschiller, did you? Yeah, okay.
Thank you, Madam Chair. Welcome.
Thank you.
Yeah, congratulations.
Thank you.
Within the testimony from the Office of the Child Advocate, you, on the second page, you outlined that the Office of the Child Advocate urges investment in a small use flexible building for when no children are present, with flexible staff job descriptions that can shift to other activities with consistent employment. Could you elaborate on what that looks like? What did you have in mind?
Yes, Emily, can you help answer
So I think part of that thinking was that you'd have staff that could shift into the community to help kids as they're in the community. So if we're going to have, and this is somewhat in alignment with the changes that came through with Senate Bill 94, which is working to divert kids, one, from even coming into the system, but then if they do come into the system, for them to each have individualized plans. And so if you have staff that could be working with those kids while they're in the community to support them, maybe support their juvenile probation and parole officers, those could be flexible use staff. That was the intent.
Okay.
Follow up.
So the intent from the Office of the Child Advocate is to provide more supports across the board for those children as they move through the system and not rely completely on juvenile justice, but provide those supports as they transition out of their high need time at the center to gradual reintegration into their communities. So it's not a full drop off. Is that what you're saying?
Definitely.
Thank
yes.
you.
And
Thank
in
you.
fact,
Yeah.
right now they're trying to do that and integrate that plan into the kids that they're working with at Sununu to the extent that they can have staff supporting them in the community.
May I follow up with one more?
One more, yeah.
Thank you. And so to that end, would the Office of the Child Advocate support on page 2 of the amended bill? I don't know where it would be in the original, but nonetheless, line 9, part B, use of evidence-based practices and research-based practices?
Yes, we would. We were looking at the language where it says the facility and programming, which is line 4. The facility and programming and operations shall include. So not keeping it restricted to evidence-based, but also being able to include other research-based that will be potentially a better fit for that specific child.
Last question, Madam Chair.
Sure.
On that same line, would the Office of the Child Advocate support adding the phrase trauma-informed evidence-based practices and research-based practices?
Yes, absolutely.
Thank you.
Representative Belanger.
Thank you, Madam Chair, and thank you so much for being here today. So much congratulations on your appointment. Looking forward to working with you moving forward.
Absolutely.
Have you had a chance to look at the bill that was introduced? I know it's your third day.
Yes.
Okay.
Yes, I have. Yeah.
Thank you. Can you, what would be the difference of completely privatizing this, and what hurdles do you think it would be for the Office of the Child Advocate if this? I'm not saying this is what's going to happen. I just want to clarify. If, in the instance, it was a completely privatized situation.
I think one in which we were speaking about was the ease of access. We do understand that we have that in our newer jurisdiction, but at this point, that's not very well known in the community. We're working on that initiative to inform the entire community that we have expanded our jurisdiction. So it is the access to the clinical notes and the incidents immediately as they occur as one primary concern. The other that we spoke about was the ability to have the flexible staffing. If they are, state workers, there's some flexibility in the ability to use them elsewhere if the facility is not housing the numbers, which we feel at some point with all of these other initiatives that the numbers are going to greatly reduce from a full what's represented here, 18 bed or potential the lesser number of 12 bed to be even lesser than that. So then being able to use that staff in a different capacity. Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
And up next is Michelle Wangren with New Hampshire Legal Assistance to speak in support of the bill for 5 minutes. How are you?
I'm doing well. Good afternoon.
Oh, I'm sorry. 1 second. Emily, will you just fill out a pink card since you spoke to? Thank you.
Would it be okay if I present with Karen Rosenberg from Disabilities Rights Center?
Sure.
Knock two birds. There you go. Thank you. Thank you. Do you want to start? Good afternoon. I'm Karen Rosenberg. I'm the Policy Director of the Disability Rights Center, and I'm here with
Michelle.
Michelle Wongren. I'm the Youth Law Project Director at New Hampshire Legal Assistance.
And we are testifying in support of SB 458, and we're representing not just our agencies, but also the Juvenile Rights Policy Group, which is a group of nonprofit organizations that advocate for vulnerable youth that includes Waypoint, New Hampshire Legal Assistance, the ACLU of New Hampshire, New Futures, and my organization, the Disability Rights Center. And as this is difficult. We're dealing with the most vulnerable children who are really challenging, and we're dealing with kids who have high intensive treatment needs, and also who are really isolated from their communities. As a state, when we're considering closing the Sununu Center, our goal should be to make sure that the youth who are committed to a locked facility, because it's necessary for them at some juncture in their lives, for themselves to receive treatment, or because they're unsafe and for the safety of our community, we need to make sure that they're going to be better off leaving than they were when they came in. And that they're prepared to be living with their families, attending their schools, graduating from high school, maybe going to secondary school, post-secondary school, and joining the workforce, not ending up at our facility that's way worse on North State Street, Concord. We don't support every aspect of this bill. We're happy to learn of a proposal for you to consider an amendment to look at a smaller number, because really it would be, we think that most children can have their needs met in the community. So getting down to 9 or 12 beds with some flexibility makes a lot of sense to us. And as I heard some of your frustration, the amount of time that potentially could be available to get this done seems lengthy to me. I'm not in construction, never had been, but it seems like a very long time. So if there was some amendment to shorten that time or shorten that escape hatch, that's fine with us. But this bill requires a child-centered treatment approach, and it requires that it be done in a facility where we know there is significant oversight. And Michelle will talk about why we can think that this can be accomplished much more easily and much more effectively at a publicly owned and operated facility. It does provide, I think there were some questions about transition. And what the bill does require is that the DCYF immediately begin implementing evidence-based practices at the Sununu Center with qualified staff, and that the provisions in SB 458 that are in, I think it's section 3, but it's Roman numeral 4 on page 2, if I'm looking at the correct version of the bill, I think I am, that all of these provisions with staff competency and the practices that are used, which actually do include the way we define evidence-based practices, it includes research-based. So it's not just limited, but that's how we just happen to define it in law. So it requires that all of these safeguards and the real-time access that the OCA has to not just being able to go into the facility, but also access to their case management database be in place, continue at Sununu Center and then at the replacement facility. So, and then the bill does not call for any kind of gap in services for the children who need such a secure setting. So what this bill does, and you can see this on, it's page 3, and it's section, I think it's Roman numeral 7, and then it continues on to section 2, that basically the facility that is now the Sununu Center continues to operate in alliance with these practices and trained staff until the opening day of the new facility. So we aren't leaving kids in limbo in this bill. So I think that was a concern that you all raised. So that is not something. We think this is the way to do this in a fiscally sound way that actually takes care of kids. We don't believe that Medicaid will ever cover children being locked in a facility. There is a provision in Medicaid that allows for the coverage of psychiatric residential treatment, but not in locked facilities. So, Michelle, maybe you should take it from here. Thank you.
Yeah, before launching into another issue, I will just point out I was doing some research as that conversation was happening, and I found some interpretation of the Center for Medicaid Services guidance that says that CMS regulations define a public institution. I'm sorry, hold on. I won't read you the whole thing. CMS guidance has interpreted correctional facilities broadly to include private facilities that are under direct contract with a governmental entity to provide correctional services, or that are otherwise acting as an institution for incarceration. So I would be happy to do some more research to figure out whether there are any loopholes in that, but my understanding has always been that Medicaid will not cover children who are in a locked-in facility, and perhaps if there were a locked facility that was not through a contract with the state, I don't know how that would possibly occur, but if there is a contract with the state for a locked facility, they are considered a public institution under the Center for Medicaid Services guidance. So, so if I can continue talking, I saw a hand raised. If it's on that issue, I'm happy to take questions on that now.
Okay, brief.
All I was going to ask, and thank you, Madam Chair, is that you forward that to me, but I would appreciate, I'm sure other members would appreciate that being
If
forwarded
you would
as
send
well.
it to the committee, we
Absolutely.
would appreciate it.
So I'll be honest that this I was doing a quick Google search, and it was guidance from a law firm that is well known for working with state agencies, and so it was interpretation of their interpretation of the guidance. But I can find the guidance. If it's there, I will find it, or if I can't for whatever reason, I will send you the guidance that I just cited to you. So one of the other things that the committee has heard today is that perhaps DCYF isn't equipped to manage a new facility and maybe shouldn't have the opportunity to do that. And one of the reasons is because we all know that there are some major lawsuits going on about conditions at the current facility and the former facility, which is going to cost the state upwards of $100 million. I understand that concern. I do. I have spent my career working with children in the juvenile justice system. Those children have been in private facilities. They've been in public facilities. They've been at the Sununu Center. And I can tell you that none of those facilities is everything we would like it to be and more. They certainly are nothing the children would like them to be and more. But what I can say is that in my over a decade doing this, we have gotten so much better, and the state has gotten so much better. When the circumstances that existed in these lawsuits occurred, we were in a different space. We didn't have the system of care. We didn't have a therapeutic model, which we are working towards and which this bill mandates that we move towards by March 2023, even before the new facility is complete. And we didn't have the real-time oversight by the Office of the Child Advocate. With those pieces in place, we have a very transparent system that not only is transparent to an oversight agency, but is also transparent in the sense that that they are covered by the right to know law. We can ask for lawsuits against the agency at any time and settlement agreements that the agency has entered into at any time. We do not have that ability when it comes to a private facility. A private facility is not subject to the right to know law. It can enter into confidential settlement agreements that will never see the light of day, and we don't know what's happening at those facilities. We do know that they're not perfect. They are subject to licensing requirements, and the licensing violations are public. And if you were to go into any New Hampshire private facility and look at their licensing violations, you will see a very robust list of them that directly impact the safety of youth. But again, there's a lot more scrutiny on the agency itself because of the transparency that we have and because of the oversight that it's under that can't be lost in this. And so while we're looking at hundreds of millions of dollars of lawsuits because we had a poorly managed system at some point in the past, it doesn't mean that we're still there. And I just don't want the committee to lose sight of everything that we have gained through the Office of the Child Advocate and that real-time oversight, where they have an integrated case management system where they can look at the records of any child at any moment. That system does not exist with the private facilities. They don't have the same case management system. Some of them don't even keep their records electronically. So while the Office of the Child Advocate could go at any time and meet with any child and have access that way. In fact, I spoke with Moira a few weeks ago and she said that if she really wanted to, she could stay the night. That's great. And I encourage anyone to do that to see what's going on. But she doesn't, but the Office of the Child Advocate does not have access to those records. And I think that that's a level of oversight that we don't want to go backwards from. So then I think, so a lot of things have been covered. I have a whole list of other things that I wanted to talk about, and I don't want to waste your time though. So let me just, I think we have covered everything else that I wanted to tell you. So I'd be happy to take any questions, and either myself or Attorney Rosenberg may have answers.
Are there any questions? Representative Altschuler?
Thank you, Madam Chair. Thank you very much for being here to answer these questions. And I wonder if you'll, if this might be in your scope. We heard some testimony in relation to another bill, but the instance applies here. Should these services be privatized? Or even partially privatized, would there be, or is it your opinion that there might be a problem with getting liability insurance for these private facilities? We are hearing that in other high conflict child services, they are losing their limited liability umbrella policies. Is that something that would be a problem if we were to do the same with this type of facility?
I mean, I know that there's someone else here who, Keith Koenig from Waypoint, could address that for you if you were to call on him. I know he didn't sign up to testify, but it's my understanding that that is an issue for some of the private companies. But I don't feel that I'm qualified to answer that really.
Yeah, and one of the things I will say, just as tangentially related to the issue of liability, is what hasn't been thought out in terms of privatization is what's going to happen if the private facility that were to take this contract does not live up to its obligations. So we're asking the state to spend potentially $1 million or more hardening a facility, and then expecting that it would be subject to a contract with the state where it has to meet certain deliverables and it has to meet certain safety requirements. And when you think about how the contracts work, the state has oversight of that. And if the facility is not meeting its deliverables and not meeting its safety standards, the recourse is to pull the contract. But if we've invested all of this money into a single facility and expect that facility to then serve children under certain expectations, we don't have that recourse to pull the contract, because then where would the children go? If it's a state facility, then the state is responsible for managing it. If it can't staff its facility, just as it did with COVID, it can pull in staffing from other places. So when the Sununu Center was not able to staff itself properly, it was able to call upon the juvenile probation officers to assist with staffing. It made sure that it was able to meet the standards that it needed to ensure the safety of youth. That's not something that could happen in private facilities, and I just don't know what the recourse would be other than yanking the contract and wasting the state dollars, putting all our eggs in this basket.
Well, I mean,
or not doing anything and letting the children suffer in poor conditions.
Yeah, I mean, a couple things. One is that one thing to keep in mind is the state does have a contract with Dartmouth Medical Center. And so they've been able to secure really high qualified psychiatric services and psychologists. So even though there's a workforce shortage in healthcare, we know that they have the ability to secure the qualified staff, treatment staff that's really needed for these kids. And as far as pulling a contract, I was the lead investigator in the Lakeview investigation several years ago, which many of you may remember included a school for kids, a residential school, and a facility for adults that was licensed by our state and also was an approved special education placement for children. And what our office uncovered was significant abuse, physical abuse, emotional abuse, all kinds. And our governor made the, initially just said no more placements there. And eventually the license was revoked. And I mean, I was proud of the work that I led to uncover this, but I'll tell you, it was very difficult because when that facility closed, there were not places to absorb those children and adults who had been yet subjected to abuse. And now they had nowhere to go. And we scurried around and tried to help people, but some people from New Hampshire ended up in Florida. I mean, those are adults. Children ended up in different placements. So it is a problem.
Are there any further questions? All right, seeing none. Thank you very much.
Thank you for your time.
Okay, last pink card. The members are getting hungry. John DeJoy.
Thank you, Madam Chair, and I hate standing between any of you and lunch. So please bear with me. I may repeat. I will do my best not to repeat. But issue, I want to make sure I don't leave anything out that is relevant. There are a number of comments that were made throughout the hearing today that I would like to respond to. Some I will not wade into. Madam Chair, members of the committee, it's a pleasure to be before the Children and Family Law Committee today. For the record, my name is John DeJoy. I rise in opposition to the Senate-passed Senate Bill 458. I continue to support the Senate Bill 458 as was originally introduced, which you've heard repeatedly today. And what we have two very different approaches. So I support the originally introduced approach, and I'll explain why. Before I begin, I do want to just a moment of personal privilege and acknowledge a very dear friend of mine, Catherine Rogers. I don't bring her up today because of what happened, but I bring her up today to point out that Kathy has worked with me on this issue for as long as I have worked on this issue. I've worked with adolescents in some capacity or another for more than 35 years, mostly in the psychiatric mental health realm. I've been aware of and working on this issue to close the Sununu Center since it opened in 2006-07. But when we talk about closing Sununu, we talk about moving children to a treatment facility that provides humane, trauma-informed care that gives the children the best chance of success. We don't talk about closing Sununu to build a mini Sununu. That's not closing, and at that, we might as well stay where they are. We put great emphasis on the state law, which says that children ought to be in the least restrictive alternative, appropriate alternative. We think that is what should drive everything that we work on regarding children. New Hampshire and our juvenile justice system finds itself at a crossroad. We found ourselves at a similar crossroad 20 years ago, following the 1990s, the rise in crime, an apparent rise in juvenile crime. This legislature chose to build a 144-bed facility at that point, and that decision framed the entirety of our juvenile justice system for the next 20 years up until where we are now. We're at a similar crossroads today. We are discussing whether we should build the mini Sununu as recommended in this bill before you, recommended by DCYF, or whether we should fully include these 6 to 12 children in the existing children's behavioral health system of care. Now, I don't consider youth prison as part of the system of care. I do consider psychiatric hospitalization, psychiatric residential treatment facilities part of the system of care. But most kids don't move through prison. That's why it's not part of the system of care. A colleague of mine used to testify before this committee and others frequently, and he said the same thing every time. New Hampshire has a long history of over-incarcerating low-level offenders. That's why this committee passed 254 last year, because you understood that we over-incarcerate low-level offenders. I would add to that that New Hampshire has and is overly reliant on institutional levels of care, both among children and adults. What the original 458 has introduced gives us the opportunity to do is to move away from that in an organized, safe manner to a system that can give kids the best chance to succeed. There are lots of reasons, and I'm going to share a couple. There are lots of reasons why a mini Sununu does not make sense. Chief among them is that the census in fiscal year 21 averaged about 12. The census this fiscal year is under 12. I think it's about 11 3/4. So we're seeing that, there's some stagnation in the census, but we also see the number of detained kids tends to be going up month over month, while the number of committed kids tends to be going down. And that, Ms. Ross appropriately said, that's variable. It is variable. But we're having more and more detained kids than we've ever had before through the history of this facility. And you can see that through the data over the last decade. It's also important to understand that DCYF has testified repeatedly that 75% of the kids at Sununu, at SYSC, are dealing with behavioral health issues. So we're looking for the best way to treat these kids. Makes sense, but we also know that kids that are committed or detained at Sununu and are released, nearly 2/3 of the time return to Sununu. If 66% of people fail at anything, that's not giving kids the best chance to recover. We have a better way, and it's the way that I'm talking about in the original Senate Bill 458. Just for illustration, assuming there's 12 kids there, which is what it's been lately, 8 of the kids who were discharged will return to Sununu. 8 out of 12. Bear with me, I moved some passages around. The most straightforward solution is the original Senate Bill 458 and add to the original language more robust oversight, as you've heard today, is required. It was not included in the original language. Through numerous conversations, it makes sense to add more robust oversight, and I'll speak to that. DCYF already has oversight as the contractor. The OCA, as you heard, already has oversight. You heard Ms. Wangerin talk about non-disclosure agreements and private agreements. One of the oversight measures we think would be essential is that contractually, the department ought to specify with the provider that there can be no NDAs to shield them from any untoward events or any critical incident events. That only seems reasonable. I would even suggest giving the OCA an additional staff person for the next 2 years, with their only job being to oversee this new contracted facility of 6 to 12 kids. And at the end of a year or two, you all can talk to the OCA about whether that's necessary, and then the OCA can use that staff person for whatever she sees fit. You see, we should never be afraid of oversight and transparency. So the more transparency and oversight we want to add to the original 458, bring it on. I'm all in for as much oversight as we can. We all want the same thing. We all want kids to be protected. There's a perception, and you heard inklings of it, but there's a perception that these are dangerous kids. And occasionally, rarely, in New Hampshire, there are children who commit heinous crimes. We can name them. That's how infrequently it happens. The vast majority of kids we're talking about are not dangerous kids. What they are is they're kids who have had a really rough start, either for personal or family circumstances. They have the most complex needs of any children in our state. And the way we, up until now, have responded to them is by putting them in jail. We as a state can and should do better with these children. They need complex needs. Yes, they do stupid stuff and come into contact with law enforcement. They ought to be held accountable, but their life shouldn't be destroyed because of it. Right? As I testified to Senate Judiciary the other day, House Bill 254, the only consequence that's off the table is going to Sununu. Every other consequence continues to be on the table. But to the extent that we can keep these kids in or close to their home community, that's what we ought to be doing. That's the purpose of the system of care. The system of care is not just group homes, it's a full range of care to provide the right care at the right moment in the kid's life in the right location. Now, by the time the kid gets into court, it may be a little late to go upstream. But as we do this, as we focus on these kids as being worthy of this level of care, we will intervene in the future consequences to prevent them from offending again. You've heard allegations that private facilities, and let me just say, I reject the concept that the original bill privatizes the juvenile justice system. It does not. What it does is it treats juvenile justice, or kids in the juvenile justice system, the same way every other child in the system of care is treated. Every program in the system of care is contracted. This is nothing more than a contract, is what it is. But let me just stipulate, any abuse towards any child in any location is unacceptable. None of us would tolerate that. And to accept for the moment that the arguments, to accept for a moment that DCOF and the Child Advocate have full oversight authority, which we've heard that they do regarding the group homes, I'm not aware of any contracts that have been removed from group homes in the last several years. I know that one was referenced that I'm not familiar with. In the last several years in regard to abusive behavior. The OCA did an investigation in December of a provider and came back with findings. The department, in their public statement through the media, talked about how they have a contracted system and provide sufficient oversight. So the department believes they are providing sufficient oversight at the current time. Let's contrast, though, that type of system of care, community-based system that I've been talking about with the Sununu Youth Services Center. There are currently 11 former staff members who are incarcerated for various offenses, primarily sexual assault or some version of sexual assault. More than 500 children have alleged abuse at that facility. I recently spoke with plaintiff attorneys. Plaintiff attorneys have told me currently the most recent allegation of abuse that they have is 2018. Doesn't mean there's nothing newer, doesn't mean there will be anything newer. But what they have told me is that currently the most current allegation is from 2018. We also have, you heard about the Victims' Compensation Fund. I don't even want to talk about the compensation fund, and I'll tell you why. We're not talking about money. We get lost in the money. We get lost in the oversight. We lose the kids in this. We're talking about children. We need to focus on this as though their lives depended on it, because it does. The final point that I'll make to you is that if to the extent that group homes treat children badly, please do not forget that we have more than 300 children in residential care on any given month. It's slightly under that now, based on the Health and Human Services dashboard. If these 6 to 12 children in juvenile justice, if the group homes are not appropriate for them, why do we have 300 other children in some of the same facilities? Why aren't we actively investigating every group home, removing every child? The answer is simple. There are concerns, but the concerns that are addressed don't represent systemic concerns. They represent anecdotal concerns, nonetheless important, but not systemic. To end my testimony, Representative Rogers, a couple of weeks ago, she received a letter during her work with the compensation fund. She told me this letter is the most compelling letter from a victim of Sununu abuse that she has received, and has asked me to read it into the record. I'm not going to read it into the record. Madam Chair, I'm not going to read it into the record because of time, but I'm going to give you a copy, but I want to excerpt a couple of points that I think are really important. This is written by a 31-year-old man, currently incarcerated at the Northern Correctional Facility in Berlin. And he starts by saying, I'm a survivor and victim of the YDC state-run facility and abuse scandal. But he goes on to say he was abused at other facilities as well, not just at YDC. He talks at length of what he refers to as years of abuse, torture, sexually, physically, mentally, emotionally. Nothing can ever take that away, but he asks for the state to acknowledge responsibility for what has happened to children. He believes that is essential both for the state and for the victims to be able to put some closure. He goes on to say that his physical wounds have healed, but the scars, the torture, the trauma have not and will never go away for this man. He talks about his symptoms, depression, flashback, shame, fear, terror, and he says, I feel it is very important for the representatives of New Hampshire to understand that this abuse is not temporary. The effects are forever. With that, I would humbly ask folks to please consider the original bill. I believe that even if it needs more work, it is a far more child-centered bill, takes into consideration most of the concerns that have been talked about today, and the ones that haven't, I'm always willing to work with anybody to make it a better bill.
Are there any questions? Seeing none. Thank you so much.
Madam Chair, can I make one comment?
Sure.
It will be quick. It's relative to House Bill 254. I know that there's Ms. Ross, and she wouldn't be surprised if she was still here, that I disagree with her. What I received in terms of data via House Finance were 2019 and 2020, all the children who were either detained or committed to the Sununu Center, and all of the charges. It didn't have the confining charge. I don't know what the confining charge was. It had all of the charges that those children were subject to. I can tell you that more than 50% of the children in those 2 years were in Sununu for misdemeanor offenses. I can tell you that if 254 passed, about 8 or 9% of all of the charges, only 8 or 9% of all the charges, would have been met for confinement at Sununu. Does it mean there'll only be 8 or 9% of the kids? Because there's multiple charges. But 92% of the charges did not meet the conditions of House Bill 254. And I'll leave it at that.
Thank you. Okay, so, yep, okay, I got one more too. I lied before, so we'll take yours too. But I just want to let the committee members know that what we'll do is when we're done with this, we'll hear the next bill quickly, if it's, because it's almost 1:30, and then we'll break for lunch. And I apologize, I really did not plan well today, so I'm so sorry. So up next is Representative Mary Jane Wallner. She's asked for 2 minutes. Where'd he go?
Thank you, Madam Chair. And I'm not going to take 2 minutes. I'm going to take much less than that because I think you've had a full morning of hearing testimony. But I will say that I was so disappointed when I saw what came back from the Senate. I've been working on this issue for many years, mostly through the Finance Committee and looking at the Sununu Center in the cost of running the Sununu Center. But again, what came back from the Senate was, again, a focus on the building and not on moving towards caring for these young people with community-based services. A number of the children will need secure residential placement, but we know that many of these children would be better served in their community and in their own homes. Some of these children and families need services. The whole family needs services, not just the child. And moving them into residential incarceration does not meet the needs of the whole family and possibly other children in the family. This bill to me, this bill feels like we're taking another step backwards. It's incarceration of these children and not looking to what we could be doing for them in their own communities with community-based services. I do not see this bill as it is written to move us any closer to providing for care for children in the least restrictive environment. I know your committee has a huge undertaking that needs to happen, I guess, before 5 o'clock tonight. You have so much information to work with. I hope that some of you have been able to look at the original bill and see some of the parts of that bill that would definitely move us towards caring for children in a much less restrictive environment. And for that, and then I think it will move on to the Finance Committee, where I think there are a number of financial questions about this bill. The way it came back from the Senate, it seems like there are just so many questions to be answered around the finances of it. Thank you. I'm glad to answer any questions if I can.
Are there any questions? All right, seeing none, thank you so much. And last but not least, I am not accepting any more pink cards on this bill. Is Keith Keening to speak for 2 minutes in support of the bill?
Madam Chair, members of the committee, my name is Keith Keening. I'm the advocacy director at Waypoint. I know you want to eat and I want to get to my car before I get a ticket, so I'm going to make this really, really fast. A couple things. I want to make it clear that Juvenile Reform Project doesn't support putting one child in a locked facility that doesn't belong there. But there are some children that are a danger to themselves or to the community that need to be in a locked facility. And I will tell you, whether you have the state build it or if a nonprofit builds it, because of PREA, which you guys understand, because of children that are certified as an adult, you are going to have a locked facility in this state. So you're not going to get around that. I think it's unfair to continue to call it a mini Sununu any more than it's unfair to call it a mini Granite Pathways. Let's not forget the state invested $2 million in Granite Pathways, ended up closing it under a year because children were sexually abused and 3 of them almost died at that facility. So I just think you need to keep that in mind as you're going forward. And finally, we're nonprofits, but we're not stupid. There's this idea that somehow out there, we're just going to have to pay any private facility just for the people they're taking care of. It doesn't work that way. If you ask a facility to make room for 9 kids, they're going to have to staff for 9 kids. And whether one child is there or 2 children are there, you still have to pay that amount of money. And so I think there's a bit of a misnomer going on here that somehow going to a private or, facility is going to save so much more money. I just don't think that's true. So I just wanted to make those 4 quick points, and I'm happy to take any questions.
Are there any questions? All right, seeing
Thank you.
none, thank you so much. I will close the public hearing on Senate Bill 458. We'll take a 7-minute break, be back for 1:30, and then I promise we'll go to lunch, and I apologize that we're running so far behind.
She wasn't going for Mom's Rising, was she? So Amy, no, because she left the church. And so it was funny, Wonder School mentioned to me she was going, but under Mom's Rising. I was like, oh, no, she's wonderful. And they wanted to go. Exactly, and they wanted to connect, but look at her in the end. This morning. And then they're starting a new program where high school kids, they're going to pay their wage. We pay them $15 an hour. They will pay I figured it. Yeah, I've heard about this. Okay. So I'm finally intertwined with it. I have a meeting next week on Wednesday with Lauren because I'm Spalding to get it all finished and connected. But I had an awesome meeting with the actual company that's doing the platform stuff. They have like an actual like a path that's mapped out for the ways. And all it's really for something that is completely. So I told him, I'm like, email me, we need to update the stuff. Program. But if you're going to do that, you have to look at how it's. Okay, perfect.
All right, I'm going to open the public hearing on Senate Bill 446, and I will call on Senator Becky Whitley, who's asked for 10 minutes.
I don't even need 10
And
minutes.
she doesn't even need 10 minutes. I'm going to hold her to it.
Thank you, Madam Chair. Good afternoon, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve Senate District 15, including the communities of Concord, Henniker, Hopkinton, and Warner. So the bill before you, Senate Bill 446, as it was introduced, established a child care workforce fund to provide grants to eligible child care programs for workforce recruitment and retention bonuses and benefits. The bill originally made an appropriation to the fund for the purposes of establishing and administrating the grant. But what you have before you is compromise language that we passed over in the Senate. The bill maintains the important findings and purpose of the underlying bill, but replaces the remainder of the bill with a directive to the Department of Health and Human Services. So pursuant to the version you have before you, the department is charged with developing a plan in consultation with the Advisory Council on Child Care. That plan is due June 30th. And the plan is to foster sustainable childcare work opportunities for working families and businesses. And we're a little prescriptive in what the plan needs to do because of the robust testimony we heard in the Senate about the importance to address the childcare workforce, which is the workforce behind the workforce. So the plan must focus on strategies to rapidly increase recruitment and retention of staffing at childcare facilities. It must include consideration of recruitment and retention bonus and benefit programs for certain childcare employers, strategies to ensure a future workforce, costs for facilities, and strategies to increase access and affordability of childcare for families statewide. So this report is due June, I think, which will set us up nicely
for the use of potential remaining American Rescue Plan funds, and then, of course, going into the next budget cycle. This committee is well aware that during the COVID-19 pandemic, we saw that the childcare workforce truly is that workforce behind our New Hampshire workforce. Working folks cannot go to work if they do not have childcare. So as a working mother myself, I have experienced this issue myself. And I think it's important to, in order to protect the interests of our working families, but also the interests of our businesses. We heard over in the Senate lots of testimony about how businesses are really struggling for workers, and what they hear from their workforce, is that one of the barriers to going back to work and to staying at work is the availability of quality and affordable childcare. And then when you hear from our childcare facilities, the reason why they cannot keep their doors open, the reason why they can't provide additional slots is because they don't have the workforce. So you're going to hear a lot about that today. And I think that this is an important first step to secure and stabilize and hopefully even grow our workforce to set us up for future success. It's good for families, it's good for business, and it's good for our economy. So thank you for your consideration. I'm happy to take questions, but there are plenty more experts behind me.
Are there any questions? Right. I have a question.
Sure.
Do you really believe that this can be done by June 30th?
Well, and I'll defer that to Department of Health and Human Services. I will say that, there is a lot of work going on in the state, not only within DHHS, but within the Council for Thriving Children, all these groups we know that are working on this. So plans are in place. So the bill as originally written, I think was a good one. And so they could just implement that plan.
Okay, thank you. All right, up next I have Dave, is it Jubei? From BIA to speak for 3 minutes in support of the bill.
I meant that to be 300 minutes.
Yeah, no. You're in the wrong room.
Madam Chair, members of the committee, thank you for the opportunity to testify in support of this legislation. My name is Dave Jubei. I'm a Senior Vice President for Public Policy with the Business and Industry Association. I've been there 22 years, and I've never been before this committee before, so it's an honor for me to be here in support of this bill. I want to talk a little bit about the BIA and why we're here. The BIA is a membership organization. We represent employers of all sizes across the state. We have approximately 400 employer members with over 90,000 Granite State employees. And they're the reason we're here today, because this is a constant issue that we hear about from employers. Either their inability to hire because of lack of childcare options, or their ability to keep employees because of childcare options. So we think it's a good idea to take a closer look at this. There has been work done on it. I think there's more work that can be done. And if nothing else, it will raise this issue the way workforce housing became a more important issue from when we started working on that in 2008. Back then, no one really understood what workforce housing is. Now everybody does. I think the lack of available and affordable childcare is another issue that needs to be raised in public awareness. That concludes my testimony. I hope you'll pass this bill.
Thank you. So I have one quick question, if you don't mind. Would this also look at the reasoning why childcare is so expensive?
I believe it likely would. I think my impression is everybody understands why it's so expensive. The problem is not so much trying to understand why it's expensive. It's trying to figure out what to do about that.
Thank you. Representative Belanger.
Thank you, Madam Chair, and thank you, sir, for being here today and providing your testimony. Prefacing this, my question is, I'm a business owner. I foster a very family-friendly business. I have had chauffeurs bring in their families while I, even myself, will watch their kiddos. Okay? So that's what I've done without government interference. So with the 400 businesses that you represent, what have they done without government interference? Because that should be the first thing that we should be considering.
Thank you, Representative. Well, first of all, I wouldn't characterize establishing this commission as government interference, but I will tell you what some of our employers have done when they have the ability to do so. We've had employers
Excuse
in
me,
our,
this isn't a commission. I'm confused on where you're getting that from. This says,
This is a study kind of thing. It's not.
oh, I misunderstood the bill then. Thank you. Please proceed.
some of our businesses have started their own child care facilities. This is happening primarily with hospital members because they have the resources and the space and the ability to do so, but it's not exclusively. It is a significant expense for employers to take on, but for those that are either progressive thinking in terms of what their employees need, or those who are doing it because they see no other options, that is something that is happening.
Representative Altschuler?
Thank you, Madam Chair. Thank you very much for being here today. So, Mr. Giubo, can you tell me, of these 400 employer members, and also welcome to Child and Family.
Thank
We're
you.
really thrilled to have you here.
Thrilled
Of your
to be here.
membership, do you have a contingency of child care providers, those business owners, as part of your membership? And if you do, what are they telling the group at large?
I want to make sure I understand. You're asking, do we have child care providers as a part of our membership?
Exactly.
Yeah, we do not. It's not that we're excluding them. It's just there is a cost associated with being a BIA member, and I think they have other things that are more critical for them to spend their resources on. We do, however, hear from them in terms of, we have a policy committee within the BIA called the Human Resources and Workforce Development Committee, and we frequently invite in as guests either advocates for child care in general, or from time to time people who actually run child care facilities, to just talk about the challenges that they face.
Thank you. May I ask a follow-up question?
Follow up.
So within your HR and Workforce Development Committee, where you're, bringing in, I'm assuming, correct me if I'm wrong, these are like lunch and learns, or your your executive board members. When you're saying that, like, you're bringing in people who own child care facilities to talk.
Yeah, it's more formal than lunch and learns. It's
Okay.
less formal than the executive committee. What it is a monthly policy committee. We start meeting in September, and then we go through the legislative session. It's made up entirely of members of the BIA, primarily those that work in human resources fields, like human resources managers or VPs, but also people who work in the healthcare industries and people who specialize in workforce development. The purpose of the committee is to look at bills like this and others affecting those areas and get input from our members about the efficacy of the legislation. And that's sort of the initial step of how BIA establishes policy.
Mm-hmm. Last follow-up.
Okay.
Thank you very much. So I think what I'm mostly curious about, because I know many of your members, and in my district, we have a number of child care facilities, and not a week goes by where I don't hear from either a child care facility or people who work and need child care. And there's disconnects in cost, in availability, particularly availability. And I'm wondering, I'm really glad that the BIA is taking an interest. Have you done your own research so far, and what are you bringing to the table now? Because I know that you have been dealing with this as an issue for a lot longer than this bill has been a bill.
Yeah, so the perspective I get from our members, it's more, candidly, it's more of an availability issue than a cost issue. And I'll explain why. You have to be a certain type of company, regardless of your size. You have to be a certain type of company to belong to the BIA, just because we're a membership organization. So you have to be willing to be willing to invest in an organization like that, which is generally more well-established companies or companies that are not struggling in order to meet payroll. So in general, those types of firms have better paying jobs for their employees. So it's not, from our perspective, for our members, it's not necessarily a cost issue. It's more an availability issue. And I'll give you one quick example. I have a colleague whose name was David Krueger. He was a lobbyist here, worked on energy and environmental issues in the legislature. You know, none of us are going to get rich working at the BIA, but, you know, we're paid.
Here either. But just saying, here either. Yeah.
You know, we're not scraping
I
get
feel
by
ya.
either. And he had, while he was at the BIA, he had a little baby girl. And about 6 months before the birth of that child, they started looking around for child care opportunities because his wife also works. And they got put on waiting lists. They live in Newington, and they, you know, went 25 square miles around looking for child care. So he worked for me for about 1.5 years, and then he left. He now works at Eversource down in Manchester. From the time he started with me to the time he left, he was still looking for a child care opportunity, and they were doing what they needed to do to get by. Sometimes he would stay and work from home. Sometimes his wife would stay and work from home. Sometimes the in-laws were there. But that's how difficult it is for someone who has the resources to find child care.
Are you all set? Are there any further questions? Seeing none, thank you very
Thank you.
much. Up next is Henry Bayou from the New Hampshire Alliance of YMCAs, and speak in support of the bill for 2 minutes.
Thank you very much, Madam Chair and members of the committee. For the record, my name is Henry Bayou, and I'm here on behalf of the New Hampshire Alliance of YMCAs. If you take all the different Y facilities around the state, Manchester, Nashua, Concord, Keene, Seacoast, Londonderry, and you add them all together, we're one of the largest child care providers in the state. And we certainly experience the trials and tribulations that this bill is trying to address. The bill as introduced in the Senate was a pretty comprehensive bill, which ran into some glitches. And so we supported Senator Bradley, who chairs the Senate Health and Human Services Committee, sort of put together the version that you have before you today, which basically is going to get the right parties together to try to put together a plan. And I think a lot of the work has been done already. So there are pieces that can be taken. So, you know, I'm somewhat optimistic that by June 30, the parties can get agreement on something. It would then be presented to the legislature, probably through the fiscal committee, and have some legislative review in that regard too. So, but we are in strong support of the bill and happy to take any questions.
Are there any questions? Seeing none, thank you very much. Up next is Karen Hebert from DHHS to speak for 5 minutes.
Good afternoon. My name is Karen Hebert. I am the Director for the Division of Economic and Housing Stability for the Department of Health and Human Services. So this particular bill is essentially to create a plan that would identify sustainable solutions to strengthen the child care profession. What we need is a multifaceted approach to try to strengthen that profession. So the department has been already initiated meetings with the Child Care Advisory Council. I'm encouraged by those conversations. We will continue to meet. I am optimistic that we will be able to meet the June 30th deadline. The child care, the Bureau of Child Development and Head Start Collaboration is one of the bureaus that I oversee that has been working tirelessly on a 3-phased approach to strengthen the child care profession. And this is all as a result of the pandemic. The first phase that we engaged in was really about the emergency response. The second phase was all about recovery and stabilization. We are now in that third phase where we're looking at long-term sustainability, long-term stabilization, and capacity building for the industry, for the profession. When I say long-term, that doesn't necessarily mean initiatives that would take a long time to get to. It includes what we use the word rapidly. There are some ideas that we're already discussing to address a rapid response as a result of this particular bill. What the long term essentially means is sustainable. What are the sustainable solutions that will help childcare providers, perhaps help them to increase wages and earnings of their workforce? So I'm happy to answer any questions you may have.
Are there any questions? Representative Lebec?
Yes, thank you for taking my question. So we've seen a lot of young families entering into New Hampshire, and part of the problem is finding childcare for their kids. Would you see the outcome of this benefiting those young families entering in so that way they can find an easier access to that?
The intent is to do just that. I mean, really strengthening the entire industry, strengthening the profession so that we can accommodate people who need childcare, including the employer community. So one of the ideas, of course, is being able to partner more with the employer community to do exactly that.
You all set? Representative Altschuler?
Thank you, Madam Chair. I have a clarifying question. You had just mentioned, and thank you very much. I'm sorry, I'm just leaping right ahead. When you were talking about the three-phase approach to strengthening childcare in New Hampshire, is that a report that a committee put together that's already available?
I would be more than happy to share that with you, yes.
Yeah. What was the name of that committee? It was in my notes. I know you said that there was a group that evaluated that three-phase approach.
It's the Bureau of Child Development and Head Start Collaboration. I'm sorry, the speaker is in our way.
No worries.
Which is a bureau that I oversee in the department.
The Bureau of Child Development and
Head Start
Head Start.
Collaboration.
Thank you.
Yes, sorry.
It's just a long
It
one.
is a long title.
And may I follow up, Madam
Follow
Chair?
up.
And so this working group already has, you've already put together some data that could inform what this bill is asking for by the June 30th deadline.
We do have some data, and I think that it's important that we try to identify other data sets that are available so that we can really make an informed decision for the legislature going forward.
Sure. Last follow-up. So
One
I
more.
guess what I'm driving at is you're not reinventing the wheel now. You already have stuff that you're working on, and you know what you need to find. So
That's correct. Yes.
awesome. So June 30th is not a daunting deadline necessarily.
No, ma'am.
Awesome. Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
Up next is Jackie Cowell to speak in support of the bill for 2 minutes from Early Learning New Hampshire.
Good afternoon. How do you do, Madam Chair and members of the committee? I'm Jackie Cowell from Early Learning New Hampshire. We're a statewide nonprofit that works to help childcare programs do their work as the workforce and the families they serve. And so just here briefly to point out that we are in support of this bipartisan amendment. It passed as a bipartisan amendment to, again, go from an appropriation from Gopher state discretionary funds to a planned to do that. And we are in support of that. We do hope the legislature and the House will also agree to support this development of a plan by DHHS in consultation with the New Hampshire Child Care Advisory Council. You'll hear from some of their leadership here. It's a legislatively enacted group to advise the department. So we do believe it's very important to have this plan about how to increase the retention and recruitment, and have it, again, as a bipartisan came through the Senate. It'd be great to have the House also put their stamp on it and say, we think this plan should happen as well. I think that will be very important. I brought with me simply some more testimony. Stay, work, play also has childcare as one of its top priorities of affordability and availability. I've got their testimony. They couldn't be here. Fred Coker, who runs New Hampshire's business on WMUR, did a bipartisan. Senator Whitley and Senator Hennessy were on his show earlier in the year talking about the importance of retention and recruitment of the childcare workforce. I have that testimony from him for today. And then I'm just sharing with you really quickly this other, back in January when this first came out, we have over 1,000, almost 1,900 signatures from parents, from childcare programs, and from over 190 businesses here in New Hampshire saying, please, let's add this tool to our toolbox, this plan for retention and recruitment, and look to Gopher for availability of funds. And again, what would happen after the plan is submitted, as said in the amendment to the governor's office, the Speaker of the House, the President of the Senate, and the Fiscal Committee, just like any other Gopher state funds, it would go to Fiscal Committee to then be passed and appropriated. Thank you.
Are there any questions? Seeing none, thank you. Up next is Mary Ann Barter, who to speak in support of the bill for 2 minutes from the Child Care Advisory Council.
Thank you very much. I'm Mary Ann Barter. I'm the chair of the Child Care Advisory Council, and I'm in support of the Child Care Advisory Council is in support of this bill. I just want to take a couple of minutes to explain why this bill is so important. The funding that has gone to child care facilities for the last couple of years has helped stabilize individual agencies and programs, but this bill presents Child Care Without Borders. It's really an opportunity to keep the workforce in the workforce so that if there's a reason why a child care provider chooses to leave their center or their program, they're incentivized to go to another child care program or agency rather than Target or Dunkin' Donuts or something else or retail establishment. It's really to incentivize people to stay in the field until things can improve. And I think we all truly believe that things will improve, but it will take time. 3 years from now, I think the childcare industry will be well on its way to sustainability and some practices that will really incentivize people to enter the field and stay there. But we are not there yet, so we need to maintain our workforce until we can get there. One of the things that is truly important about this bill right now is that Maine recently put in their budget $12 million worth of incentives for childcare providers, and Massachusetts is looking at $60 million worth of incentive for childcare providers, the individual teachers. We want to maintain our workforce, and we also want to make sure that our workforce stays in New Hampshire. The last thing we want is for the very talented people that we have who are willing to continue working in this field decide to drive to Maine or Massachusetts to do it. So this is truly important. And I'd also like to say that I agree with Karen Hebert, our colleague at DHHS. The Child Care Advisory Council is very optimistic that we will be able to meet the June 30th deadline, but I do believe that passing this bill will ensure that we meet the June 30th deadline. And that's all.
Are there any questions? All right, seeing none, thank you very much.
Thank you so much.
Up next is Mark McMurphy to speak in support of the bill for 2 minutes from White Birch Center.
Thank you, Madam Chair, and thanks to the committee for allowing me to testify. I got into childcare not out of passion. I was in business for the first 25 years of my career, and then I was serving on a board, asked to serve on a board at White Birch Center, and I ended up becoming the executive director, and my passion has grown quite a bit. With all the business experience that I have and having an MBA, I was able to do a lot of work at White Birch to get our finances organized and do all of the proper budgeting that any business should do. And having done all of that, why is childcare expensive? I heard you ask that, Madam Chair. It has to be even more expensive, really, to make it work for long-term stability, because otherwise you just can't pay the workforce what you need to pay for them to turn it into a career and to be stable. And unlike Some other options if a restaurant is short on labor. In our town of Henniker, great town, there's few other restaurants. So if they're closed on Tuesdays, you can go to another restaurant. But with childcare, that's not an option for a lot of families. And to stabilize the workforce and to keep them in place and to have a place for working families, this bill, which I support, takes steps in that direction. And I think that's really healthy, not just for working families, but for the economy. I'd love to see the economy stay strong in New Hampshire and not have it falter. I know housing's an issue, but childcare is also a very big issue, and this bill helps to address that.
Are there any questions? And then thank you so much. Up next is Shannon Tremblay to speak in support of the bill for 2 minutes from Little Blessings.
Hey, thank you. My name is Shannon Tremblay. I'm the director of Little Blessings Child Care Center in Portsmouth, as well as the vice chair of the Child Care Advisory Council. Thank you for listening to our testimony today. I miss the days of classrooms full of children and meeting new families as they come to tour our center in hopes of being able to enroll their child. Little Blessings has always had the reputation for long wait lists because of our wonderful care. Unfortunately, now we have long wait lists because we don't have staff. These days, I walk by darkened classrooms where children were once happily engaged in fun learning activities. Mornings are spent hoping that nobody's called out and rearranging schedules in order to meet state ratios. Our enrollment is down by 60%. We haven't been able to enroll any new families in our program in over a year due to staffing. We're barely making room for new siblings of our older children. Without staff, we can't open classrooms. Without staff, we can't enroll children. Without staff, we cannot meet the needs of families who desperately are looking for care. When I first started at Little Blessings, we had roughly 25 staff, full and part-time. We currently have 12, and only 4 of those are qualified teachers. We're thankful for every day we don't have to close another classroom or lose another staff member. The effects of the pandemic continue to hit hard. The past 2 years have been a roller coaster ride and not the happy fun one. This one's white-knuckled, dark, scary loop-de-loop ride with twists and turns you can't see coming. Directors and teachers are exhausted, emotionally, mentally, and physically. It's a struggle to put your whole heart and soul in your career every day, only to be left feeling like you're on your own little island and nobody speaks your language. This bill has not come at a better time. We cannot afford to lose any more valued teachers. In fact, this bill has the ability to strengthen and rebuild New Hampshire's childcare workforce. I've been getting calls from HR departments who are looking to hire candidates, but that person cannot find childcare and therefore cannot accept the position. Every day we have an average of 6 to 8 calls or emails from parents desperately looking for childcare. We must tell them that we don't have any idea when we'll have an opening, as it all depends on being able to find, hire, and retain staff. We need this bill. New Hampshire's childcare industry needs this bill. New Hampshire's families need this bill. Thank you for your time today and your continued support.
Are there any questions? Seeing none, thank you very much.
Thank you.
Up next is Corlin Hoppy to speak for 2 minutes from the Rochester Child Care Center.
Thank you. I appreciate your guys' time. I'm Corlin Hoppy. I'm the executive director over at Rochester Child Care Center. I'm a newbie. I've only been doing this for 7 months, but I have my master's degree and I understand the business world. I work to collaborate with many outside industries to make sure that we offer care, but at this point, I have 40 babies to toddlers on our wait list. I have 90 employees under me, and we're still not able to pay them or compete with any other industry. I give our lead teachers have bachelor's degree between $17 and $22 an hour. In the state of New Hampshire, rent is $1,400 a month. If you are not married like myself with an electrician, I'm not able to work or be able to stay in this field. So as an agency, we're okay and we are going to make it, but we've had 3 other centers close down right near us. So the beginning of May, our wait list will probably jump up between 60 and 70. So we're already at the point of chaos, and we want to come to you as a point of an opportunity. This is the first time you can really truly invest in families and children agencies like mine in order to keep our people here, because we're going to get to a point that we've run them all off and no one wants to hang out here. So I've talked to the mayor over in Rochester and been involved in a lot of the Rotary conversations about the building of the cities. But another childcare center and a few small family childcare centers are the only ones in town. And I'm not sure how much longer those other ones are going to make it. So the reason Rochester Childcare works is because we have a large school age program. Our school age program offsets the cost of our early childcare program, which would put us into debt if we didn't have. We're okay for early child care teachers right now in our actual agency, but our school age program is suffering. And it's really that program that pays our teachers and for our administrative costs. So we're at a point where just in constant putting out fires. If you give us the opportunity to have this plan and have real discussions with the state, we might in turn be able to thrive again and really help the rest of our economy. But for right now, we're pitting parents against agencies. We're competing with other childcare industries. Indirectly, because of 2 hires, I've shut down classrooms in other agencies. So I'm here in 3 different hats. As a parent of 2 children who is struggling to stay in this state, as an executive director of an agency, and as a person of New Hampshire. So if you could, I hope that you guys would just invest in our children and families and continue to help New Hampshire stay. Thank you.
Are there any questions? Seeing none, thank you so much. Up next is Lynn Roulette to speak for 2 minutes, representing Nellie's Treehouse.
Thank you for having me, and thank you for taking the time to listen to us. You've heard from my colleagues. We're all in the same boat. I run a center of 70 children. I have a wait list of 77 children. I get daily calls from parents. When will you know? Can I get a space? How can I get in? It's horrible to have to tell a parent, I don't know. We're short-staffed. I work a 13-hour day to support my staff, and they don't make enough money to support themselves. We've raised their benefits, we've raised their wages, we're doing everything we can, but when you can go to McDonald's and make $25 an hour or $20 an hour, and it's a little bit easier than having to sit with a bunch of children all day. These are our future. These children are our future. They're our future workforce. And if we can't support them and their families, we won't have a workforce. We won't have a future workforce. And my colleagues and I will struggle to survive. We hope that you'll take this bill into great consideration. New Hampshire families need our help. Our children need consistent, educated, qualified individuals to take care of them. Not a babysitter. I'm not a babysitter. I don't sit on babies. I am a child care worker. I take care of children all day when their parents need to work. It is the foundation of their education, and it is the future of our state. And what better to put your money into than the future of our state? Thank you very much.
Are there any questions? Seeing none, thank you. Up next is Devin. Is it Quinn or Owen? I can't make out the last name. I apologize. Okay. Quinn, to speak in support of the bill, she does have written testimony from the New Hampshire Women's Foundation. She asked for, I think, 3 minutes.
I think I can do it less than that. Chair and members of the committee, excuse me, my name is Devin Quinn and I'm coming from the New Hampshire Women's Foundation. In addition to the previous testimony before me, I just wanted to add to the discussion the specific impact the child care crisis has on women. Women make up 86% of child care workers in the industry and the field itself, but among essential care work, the essential workforce, it's 68%. That means women are the majority of social services, healthcare, grocery, retail, convenience stores. And the thing about all those jobs is that they can't do it from home. They can't do that work from home. And when childcare is an issue, when they call out, that's ripple effects throughout the entire economy. And certainly childcare impacts a whole family, but we've seen during COVID when most families at some point lost school or childcare. It was actually mothers were 4 to 5 times more likely to reduce their hours or completely leave the workforce to take care of childcare. 15% of New Hampshire workers who would be in the workforce who are not cite childcare issues as the main reason why they're not in the workforce. And when women leave the workforce, that is impacting their career trajectory. It's impacting their financial security moving forward. Women have always been the backbone of the workforce, working outside the home, working inside the home, taking care of children inside the home and outside the home. So this bill would not only support the economy and this sector, but specifically women as well. Thank you.
Are there any questions? Seeing none, thanks so much.
Thank you.
And that, folks, is a wrap. So I'm going to close the public hearing on Senate Bill 446, and we will come back at 3:10.
You want to know?
I know.
Why don't you just do what other committees have done, Kim, and say this was drafted in error? That I meant for it to say 6. And if the committee's good with that, then you can get the formal one drafted. I mean, committees have done that forever. Yes, yes. If it's state run, it's got to have 254. And the one that Kim showed me before does have the 254 language.
That is the second one I showed you, right?
Oh, good.
Okay. Oh, it's in my hand. So unfortunately, aha, there it is. Okay, hold on one second. Bear with me, everybody. Unfortunately, we're going to have to come back next Tuesday morning. We'll have time to get 458 out because we have to get that out today. But unfortunately, we're going to have to come back next Tuesday. Sorry. We'll probably do 458 and 446. And then we'll come back and finish out the rest next week. So just bear with me one second. Where did it go? Could I please get 25 copies? So Karen, I just sent an amendment upstairs to be printed. Do you have time to make sure she gets that email? Thank you. Okay. So we'll start with Senate Bill 446. Representative Nelson, do you have a motion?
Thank you, Madam Chair. Yes, my motion is out to pass.
Do we have a second?
Second, Madam Chair.
Seconded by Representative Belanger. Discussion? So I'm just going to say I think this is going to be really informative and really helpful. So I'm happy to see that this will go forward. Is there any more discussion? Representative Yokella.
Can't they make this plan without having a bill? I mean, is there a need for having a bill to say make a plan?
Well, I think that they do in order to bring a plan to fiscal. Perhaps maybe it just holds their feet to the fire. Is there any further discussion? Okay, seeing none, I'll have the clerk call the roll.
Representative DeSimone.
Yes.
Representative Yokella.
No.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Cross. Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Alicea.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Nutting Wong.
Yes.
Representative Altshuler.
Yes.
Representative Petrino. I'll be voting yes. Madam Chair Rice.
Yes.
Motion passes.
Do you have any objection to it going on consent?
No.
Okay, so without objection, that will go on a consent calendar. Can you give that to Jody?
What was the final count, please?
13-1-1.
Thank you.
Okay. So next up is Senate Bill 458. Do I have a motion, Representative Belanger?
Yes, Madam Chair. I move OTP.
Okay, second. So the motion is OTP, right? Yet we have to introduce the.
I apologize. I said OTP and then I was like,
Oh.
so I'm sorry.
Okay. So I'm just waiting for the copies to come down. So the amendment that I put in puts 458 back in place, adds SB 254, which were the condition reducing the conditions of confinement at SYSC, but it also starts with a 6-bed facility. And the thinking is then the finance committee can negotiate up if they would like, but I would really like a strong showing of support from this committee that we do not think it is okay to put kids in jail, but yet they'll still have a facility for the worst offenders. Did I explain that okay? So I'm just waiting for that. I have copies of the amendment that say the 12-bed facility, but if you want to start looking at it, but every 12 is going to be replaced with a 6.
So question, if I may?
Yes.
So, House Bill 254, what's the bill that's in there?
Oh, yeah,
294?
HB 254.
Okay, HB 254.
That's the one that we voted out on
Right.
the conditions.
Yep.
Yeah.
And the amendment has 6 beds?
Yep.
And are the 6 beds privately ran?
Nope, they'll be run by the state, by
They'll be
DHHS.
so the 6 beds will be run by the state?
Yep.
And is there a limbo period still with respect to sending kids out of state if the facility's not built before they shut down the Sanuda Center?
No, I don't believe so. I mean, I can let you look at this one if you want. Just keep in mind that it's 12 beds. I mean, it's 6 beds, not 12.
Right. Yep.
Did you guys want to look at these or wait for the other one so we don't get confused? I'm sorry, I got a mess. Yeah, I'm just waiting. I sent it up there. Karen's going to bring it down as soon as it's ready. No, not that one. These are nothing. There they are. Yes, please.
Okay.
Yeah, no, those are, that's trash, that's trash.
Recycle bin.
I believe.
Yeah, there's one in the office, yeah. Thank you.
I believe I voted against 254 in this committee.
You probably did.
Because it says 14-1 out of the committee, and I think
Yeah,
I
I'm
vaguely
pretty sure
remember
that was you.
that's me. So that's interesting.
So you'll probably vote against this, right?
I think the die is cast.
Madam Chair?
Yes.
That wasn't the
I know that wasn't the chair.
But I had a
Yes.
question. I'm sorry.
Representative Alicia.
I haven't read through the whole thing as yet. I probably should wait and ask a question. So everything's the same except for it's 6 beds instead of 12 beds.
That was in the other amendment, yeah.
That was
In the
okay, can
previous
she-
amendment.
Okay, I just need
So
to-
we've combined like all 3 thought processes, right? We've combined the 458 as it originally was with SB 254, which we passed out of here. That reduces the offenses for placement
Okay.
at Sununu. And we've added the 6-bed facility. And then we'll let finance take it from there.
Okay, my question is, so suppose there are 8 individuals.
So
Then
they
break-
can, what I would like to see in the design is perhaps, and I had talked to Director Ribson about this before, is temporary walls, space, a little extra space so that they could manipulate the so-called pods, right? When, in case, so say you had, 2, 2, and 2. If you needed 4 and 2, you can mix it up.
Okay. And it's gonna be done still the time period.
Still the same time frame.
Would it need,
Um,
I'm sorry.
I would like to see it sooner, but that's something that we can probably leave to finance, because by the time they get it, they'll have a better aspect of the price of everything and what they're going to be able to do.
I feel dirty, but that's
You
okay.
do? Why do you feel dirty?
Because I don't think it's on finance, that part. I think that
Well, my only concern is if we change that date to make it sooner, then we leave ourselves in a position where children may have to be placed out of state, and we don't want that to happen.
Okay.
You know, that's my feeling on it. While I don't want it to go that far, I don't want to see kids sent out of state either, because we have to close Sununu.
Right.
You know, Representative Yokella,
What is the amendment number that we are talking about?
1470H.
Madam Chair.
Does anyone have that?
Yes, she just
do you
passed
guys
them
have
out.
that? Must.
Madam Chair.
Yes,
I
I'm
was
sorry.
I was just hoping that the 6s
Do you have
have
another
the
copy?
12, so it will cut the time down, and we could at least do that.
If we had the 6, it could cut the time down, but I don't see that happening. It's government. You know, everything just takes forever, I feel like. Do you know what I mean? And then if we do move the time for,
Do you have another copy?
Oh my God.
I think there's more.
I'm sorry. Go ahead. I apologize.
Oh, I was just throwing things out because first it was 18, then they said 12, and then if we went with the 6, then I was hoping that would.
I
cut
know.
it in
I would
half.
too.
But I also worry. I mean, I know of 6 kids right now that it's going to be more.
But you know, I mean, so here is my huge issue, right? Do we put juveniles adults who create misdemeanors, are they put in jail? For some of these offenses, these kids are being put in jail, and we don't even put adults in jail half the time. You know, so I try not to get emotional over this, but I can't help but think about all those cases of how many people whose lives were ruined because they were placed at Sununu and what happened to them, because there are lifelong issues. Drug addiction. How many of them died from suicide or drug overdoses because they were trying to cope with what happened to them? I don't want that ever to happen again. I just can't even stand it. And I'm sorry I'm getting emotional, but it's just something that just tears me up. We were supposed to be looking out for them, and we failed tremendously. So I apologize. And I'm a little bit of a mess these days anyway, so, you know.
No, I
But-
appreciate, if I may.
Yes,
I
please.
appreciate your honesty, and I'm very emotional about it as well. I do work with sex offenders, as you know.
Yeah, I know it.
And I'm nervous. I don't want to set them up to fail.
Right.
Because of the past, not watching the hen house as they should have been.
Right.
I don't want
right.
them to suffer. You know what I mean? I don't
I
want
do.
to make a rush decision because of what we know happened.
Right, right. Unfortunately, so I've been working on this all week. It stinks that it has to be out of the committee today. You know what I mean? That's the part that stinks. So I feel good with the 6 beds and giving finance time to look everything over. And if they want to raise it a little, they can. But I want us to send a strong message to them. Huh?
Wish those kids ought to be released.
Yeah, right. So I just, that's where I am with it. Does, I mean, Representative Alcia, do you have anything else? Or is there something you would like me to change? I mean, I can send in for another amendment. Of course. I hope I have it.
All right,
I hope
thank
I
you.
have an answer.
And I'm not trying to stall, but
No,
my
no,
question
no.
is, what would happen if it went to interim study? Could the kids still stay there until
No, that facility has to close.
it has to close?
Yeah. So, that's why we have to work really closely with Representative Malner so that we, I mean, like she said, she's been doing this for years,
She's got the whole finance committee to work with.
Right. So, I mean,
I just feel like
I know what you're saying. I do know what you're saying.
Thank you.
I totally get it. I really do.
Thank you.
So
Yes,
if I
go
may,
ahead.
The amendment doesn't reference research base either, right?
Oh.
Well, I see it.
No, I
it
didn't
says
put that-
evidence based.
is that good?
No, that's fine. That's something we may want to.
Okay.
We may want
That's
to change.
something we can change later on though, right? Because we've got time for that.
Okay.
Right? Yeah. Representative Yokella?
Thank you. It's already in law that it's going to be closed. And that was in HB2, and so that's already the paradigm that we're living in. And so if we interim studied this, then it would just close without a plan, kind of a thing.
Right. We need a plan.
And so that is obviously a concern. And as far as the research-based stuff, I looked at 170 and it seemed like there was a lot of options as far as stuff that is not just it talked about things that were not just evidence-based. It talked about more things than that, so I'm not sure that should be a sticking point, but obviously I'm not sure that I'm going to I didn't support 254, and so I'm not going to support 254 now. So
why am I not
so
surprised?
that is all that I have to say on that. Thanks.
Okay. Representative Litchfield?
Thank you. Can you please just walk me through the beds one more time? So we listened to testimony several times this morning where we currently have 12 children. So I hear what you're saying, but what happens if we need 12 beds? What happens? Do those other 6 children potentially go out of state? I mean, they're not necessarily going to be let go.
So with SB 254, I do believe that will help bring the census down, but it will also send the lesser offenders to the community-based treatment places rather than the jail. Did that answer your question? Representative Smith?
So are you proposing the 6 beds for what we talked about earlier?
Yes.
Like just for felons? Just for the
pretty
major
much.
felonies that kids, would it be
Yeah.
like the kids who are
Murder
even
their
charged as
parents.
adults?
Yeah.
That for a place for them to be without being in adult jail, adult prison? Okay.
Yes, Representative Yokella. I'm sorry. I apologize.
There's I guess a discussion to be had about whether or not detained people, because right now a significant number of people at the Sununu Center are not actually committed there; they're just detained. And so, do they have to be detained in this 6 beds facility? I don't think that's
No, they
necessarily the case. They could be detained
Right.
elsewhere. And so the 12 people is including the number of detained people and not, and
Right.
so that may be a factor to bring in. And just in reference to Representative Smith's comment, it's not just felonies, it's violent felonies that are, because we're still letting regular felonies that are not classified like in this legislation as violent, essentially, to not be committed. So those felonies under adult situations may actually lead to jail time if they were an adult, but the felonies under 254, HB 254, would still let them not be committed. Thank you.
And, you know, I really would just like to see us setting these kids up for success. That's really, I think, the most important thing is we want them to succeed, and we want to give them the tools that they need to succeed. And I think that we have the ability to do that without jail. Representative DeSimone.
Thank you, Madam Chair. I think that one of the parts of this discussion that we're missing is the fact that last year, the governor set aside some monies for juvenile diversion programs. And that's where a lot of kids are going to be dealt with who are not violent, committing violent felony crimes. So with the governor's money going to juvenile diversion programs, we're helping my full disclosure here, my program sees hundreds of kids a year that would normally go to the Sununu Center. But they go through diversion programs and they're successful. And that program sets them up for success. I've had many kids come back to me and say, guess what? I just graduated college or did this, and I just got a management position in this facility that I'm working in and whatnot and so forth. These are kids that are going through diversion. So that money is being well spent. Having said that, since that money is going there and the Sununu Center has to close, done deal, I think that we need to realize that the amount of kids that would be going to Sununu Center is decreasing due to the diversion programs. So there is the room for the felons. Thank you.
So, if I
Representative
may,
Long.
Yeah, I get the community-based services.
Yeah.
However, what is acceptable for a waiting time for a child that needs those services? And that's in your bigger municipalities like Manchester, Nashua. There's wait time. You know, this child needs this service. Great. We'll have an opening in a month. Is that, I mean, I prefer that when a child needs services, they get them the next day. So when we look at community base, we have put money into community base. However, your larger municipalities, it's usually split up through municipality, and your larger communities, which have the heavier youth
Caseload kind of.
caseload.
Yeah.
We're short capacity. We don't have the capacity. So I get that. I get this amendment and I'm going to support it. But when we talk about community-based treatment, let's be sure that every community has community-based treatment that a child doesn't have to wait a month to get into,
Right. That's a good point. Thank you. So is there any further discussion? Representative Altschiller?
Thank you, Madam Chair. Could you clarify for me, because I in either version of the bill, they're both the same in this particular point, but I'll refer to the amendment that you just passed out, page 3, line 30.
Page 3.
Is the sum of $1 there so that the Finance Committee can decide how much gopher and how much general care? Okay, thank
Yep.
you. That's
And I know that they had said they wanted us to put in the 15 million, but I think that we leave that dollar amount for finance to figure out what they're going to need. You know, we're just really not the money people. So I think, but by placing that dollar in there, it gives them a line to put the money in. Is there any further discussion? Oh, Representative Belanger.
Thank you, Madam Chair. Honestly, I don't know where to begin. I started my journey in the legislature this year. Prior to that, I was a victim at the Sununu Center. This despite the process, this is the best solution moving forward. And I encourage you all to support this amendment. It is not the best situation. But I support it. I don't agree with privatizing the facility. I believe the state needs to own it. I don't believe in locking kids up. One of those kids, probably one of the most successful kids out of that facility. Say one of. We can be better. And by we, I mean kids in that situation. We're not bad kids. We all hear that. We all know that. So that's all I wanted to say with that, Madam Chair. Thank you for the point of privilege.
Thank you, Cody. Thank you for sharing. Is there any further discussion? All right, so did I move the amendment? I don't think I did. So I move amendment 20221470H. We've had our discussion. It's been seconded by Representative DeSimone. And when the clerk's ready, we're voting on the amendment right now.
Representative DeSimone.
Yes.
Representative Yokella.
No.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Cross is not with us. Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Aliseo.
yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Nutting Wong.
Yes.
Representative Altschiller.
Reluctantly, yes.
Representative Petrino, I will be voting yes. Madam Chair Rice.
Yes.
Motion passes 13-1.
So now you make the motion.
Madam Chair, I make a motion OTPA.
Do we have a second? Oh, seconded by Representative Long. Is there any further discussion? Seeing none, I'll ask the clerk to call the roll. What? I'm sorry, I didn't see you.
Thank you, Madam Chair. I just want to I'm uncomfortable that we haven't had any time to process this and to think about this in less than an hour. So I preface my votes and my questions on feeling very, very rushed and feeling
I feel
this,
just as rushed. I think the timeline stinks, that the time frame that we have to get this done, because it goes to a second committee. And we didn't get this until last week, and they were sending it straight to finance. And I said, oh no, that's coming to children and family law first.
So just to clarify, on line 17 of the amendment we just adopted.
Which page? I'm sorry, page 1?
Page 1.
Oh yeah, okay.
This YDC will be operated by the state.
Yes,
And the oversight will be by the state.
yes.
Okay. Thank you.
Is there any further discussion? All right, seeing none, I'll ask the clerk to call the roll. The motion is ought to pass as amended.
Representative DeSimone. Yes. Representative Yokella.
No.
I didn't hear that. I apologize.
No.
Okay.
I could have told you.
I assumed, but I still didn't hear it. Okay, thank you. Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Cross is not with us. Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Alessea.
Yes.
Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Nutting Wong.
Yes.
Representative Altshuler.
Again, reluctantly, yes.
Representative Petrino. I will be voting yes. Madam Chair Rice.
Yes.
Motion carries 13-1.
Thank you all so much. And so then we'll be back to finish out the rest of them next Tuesday at 10 o'clock. And we'll try to whiz right through, right? So we can be done. Okay. 10 o'clock, yep. Can you pass that to Cody?